For judgment, item number 15.
In view of the above, this petition is disposed of with the direction to consider the applications of the petitioner within a period of 3 months and dispose of the same by recent order.
Pleasure, Lordship.
May please, your lordship.
Uh,
My lord, allow me to mention item number 9 and 10. My lord, this is a part heard matter.
Hmm.
However, my lord, I have some difficulties today. So if this can be taken up on Thursday again.
Thursday.
Yes, my lord.
Okay, it's okay.
Yes, no objections. Your
I
Honor.
second the consent.
Okay. What's the matter? On, give a date. Thursday is what? Next Thursday,
Coming Thursday.
19th, your
so
Lordship.
19th, on 19th June, on the prayer of the learned councils for the parties. As a part third item.
Oblige, my lord.
Lordship, please.
May I please, the Lordship? Lordship, I beg to mention item number 8, Lordship. Lordship, I'm here to file affidavit in opposition on behalf of respondent number 6
Hmm.
to the amended petition filed by the petitioner.
Learned counsel for the government respondents, Mr. V. Zimomi. So he prays for how much time? 3 weeks time to file an affidavit in opposition to the reply.
To the amended petition
To
filed
the,
by
okay, to the amended read petition filed by the petitioners. So
by pleading respondent number 6.
Okay. prayer is allowed. Learned counsel for the petition is present. Is the matter after 3 weeks.
May it please, your lordship. Lordship, I beg to mention here in item number 6. May I pray that this matter be listed after 2 weeks, my lord.
Item 6. Criminal appeal.
Lordship.
Learned counsel for the petitioner. She such and such prays for
2 weeks.
2 weeks time. For listing the matter for hearing. On what ground?
Lordship, here, we have some difficulties, lordship, for that.
Because he has some difficulties today. Learned additional AG, or PP, I think, Learned PP, Ms. V. Shukri has no objection, list the matter after 2 weeks.
Much obliged.
May I please, my ladyship. I beg to mention item number 12, my ladyship. I pray that this matter may be posted on Monday, 23rd. I've taken the consent for the other party also.
List the matter on 23rd June on the prayer of the learned counsel for the petitioner.
Respondent.
Respondent. Learned counsel for the petitioner has no objections. List the matter on 23rd.
May I please, your Lordship. Lordship, I beg to mention hearing item number 7. I'm appearing on behalf of Mika HIA. This matter may kindly be listed after the vacation.
List the matter after the summer vacations on the prayer of the learned counsel for the petitioner.
Lordship, please.
My pleasure, your lordship. Your lordship, I beg to mention hearing item 13 and 14 on behalf of people. With the consent of the parties, if this matter can come up on Tuesday, your lordship.
Next Tuesday.
Yes, lordship.
Lordship, I have instructions that if this matter can be listed after 2 weeks, Lordship.
2 weeks then.
Lordship.
List the matter after 2 weeks on the prayer of the learned counsels for the parties. 13 and 14.
Oblige, Lordship.
Oblige, lordship.
Your Lordship, I beg to mention item number 2. We are yet to file our reply. Kindly grant us 2 more weeks.
CGC. On
No,
behalf
I'm for the
of
petitioners.
petitioner. Okay.
Yes,
Learned counsel for the petitioner prays for 2 weeks.
yes, your
2
Lordship,
weeks
2
time
weeks.
to file a reply to the affidavit of the state respondents. No. Affidavit
CGC.
of the CGC.
CGC.
Yes. Prayer is allowed. List the matter after 2 weeks.
2 weeks.
3 weeks. You also party.
Yes, my lord, I'm appearing for respond number 3, 4, and 7.
Learned government advocate Tiba Pom appears for respondent number 3,
4
4, and 7.
and 7.
4 and 7. Are you also filing affidavit or
No, my lord.
No.
Yes, my lord.
this after 2 weeks?
Much obliged.
Right, Lordship.
Please, your lordship,
Yes.
I beg to mention item number 4.
Hmm.
Your lordship kindly allows a week time to file our wakalat number.
For respondent,
Respondent number 1,
one. Learned counsel, such and such, prays for 1 week.
1 week.
1 week time to file wakalat number on behalf of respondent number 1. Praise the Lord, please the matter after 1 week. Petitioner, appellant, absent. Yes,
For
Much
motion,
obliged.
item number 16. May I please, your lordship? May I please, your lordship?
yes, what is it?
Lordship, here, in this case, the leading counsel is Farid Ahmad from Tinsukia. He's on his way, your lordship. I've just contacted him. He said that he will take about half an hour to reach the court.
Please
So
follow-
this matter can come after the listed item, your lordship.
follow up later.
Obliged, madam. For admission, item number 1.
Yes, this is that case.
Yes.
Lordship, I need to get instruction from the newly implemented respondent number 3. I'm
From?
yet to newly implemented respondent
Oh,
number 3.
newly implemented.
I'm yet to receive instruction from the newly implemented.
Who is the newly implemented respondent?
The director. Earlier, the former director has been transferred and then the new director has been appointed, but he was implemented in the month of October
Last year,
this year. Last year,
last
yes,
year,
last year. And then the former director, he has already filed her affidavit stating that in view of the petitioner's case was not put up before the district level verification committee, my case cannot be considered for regulation. That is the only stand they have taken. And then I don't know if the newly implemented the director also.
Let this matter will come up after 2 weeks.
See, the thing is, the take up in 2 batches in a year, January and July. So if they miss this July, again, it will go to January next year.
Yes, yes.
So that is the problem.
That is the
That is the
problem.
problem.
So that they have to be included in the July list.
Yes,
Yes, you convey that. Okay.
I'll convey
To
that.
the respondent. Council, Wellington appearing for respondent number 1 and 3. 1 and 3, isn't it?
Yes.
Correct, yes.
1 and 3. Please for some more time to receive instruction from the newly implemented respondent, that is the director. That is she's. They just say newly implemented respondent. Stop. List after 2 weeks. And on the next date, the learned counsel for the respondent number 1 and 3 shall obtain the necessary instructions as to whether the name of the petitioner has been forwarded for consideration. In the batch to be taken up with effect from 1st July 2025. So list after 2 weeks. Let's
Obliged.
For admission, item number 3.
May I please, your lordship. My lord, this will be taken up for hearing. So in order, if want to short orders to be passed, then that can be passed.
Yes, Lordship. After the orders, Lordship.
Orders, only 1, 2 orders are there. If
Only
that
one
can be-
item left in the part.
you want to take up as admission hearing?
Yes.
Yes,
This one.
this for disposal, yes. Order is gone. Oh.
Thank you.
Done. Everything done. Acha, acha.
Well, I think it's all
Okay.
adjourned.
Then in that case, the instead of IA,
Hmm.
the WPC 32, the main petition, it can be heard today and disposed of. The challenge in this case is that the final seniority list of the assistant headmaster in school education department published in 2025, whereby the name of the petitioners have been shown below, down below the private respondents.
Seniority,
Yes,
seniority matter.
seniority. The petitioner is saying that the seniority should be seniority position in the case of promotees
Hmm.
should be made and arranged in terms of the rules.
How many
Yeah,
affidavits?
yeah. Short fact, I'll just read out a repetition, just to know the facts.
Doesn't seem to be very short. Anyway.
My lord. My lord, I'll just start from paragraph 2. That the petitioners are aggrieved by arbitrary fixation of their seniority vis-a-vis the private respondent 3 to 37, which has been done in complete violation of the statutory provisions holding the field. My lord, after filing this writ petition, this honorable court has allowed the private party, respondent number, private respondent number 38 to 155. They have become a new private respondents.
Okay.
There before this honorable court also. 3, that the petitioners and also private respondents are all holding the post of assistant headmaster for brevity AHM junior grade, to which post they were promoted pursuant to the recommendation of the Departmental Promotion Committee for brevity DPC. Prior to that, they were holding the post on official basis. 4, that the petitioners enter into service as graduate teachers. Some of the private respondents enter as primary teachers who were gradually promoted to the post of graduate teachers, and some of them directly enter as graduate teachers. On completion of successful and satisfactory service, they were all promoted to the next higher post of assistant headmaster on officiating basis by a common order. NHA is the officiating yard. May I come to paragraph 5? I'll just
Yes,
come to
yes,
relevant
yes.
paragraph only. That after such official promotion, all such promotees, including the petitioner and the private respondent, were considered for regular promotion through the Departmental Promotion Committee, DPC, conducted by NPSC. The DPC was constituted was NPSC and commission. On the recommendation of DPC, the government of Nagaland in the school education department, represented by respondent number 2, the commissioner and secretary to the government of Nagaland, the Department of School Education issued common regulation order, white number so dated 07/06/2024. As will be evident from the said notification, the effective dates of regular promotion of the petitioners are prior in point of time than that of the private respondent. That is the whole issue. The petitioners have been regularized or promoted to the post of assistant headmaster junior grade 2 on the same date, whereas all the petitioners, my lord, 1 to 26, they were all regularized or promoted on the same date.
Same day.
Whereas the private respondents have been regularized or promoted to the post of assistant headmaster junior grade 2 on different dates and months. The chart given below will show the effective dates of regulation for both the petitioners as well as the private respondents. Number one, private respondent petitioners 1 to 26, their effective date of regulation is same date, 19/01/2023. Then in the case of private respondents, private respondents 6, 11, 16, 19, 32 are on 20/01/23, 1 day below, 1 day after us. Then private respondent number 14, 21/03/21, below after us. Private respondent number 24, 27, they are regularized on 05/04/23 after us. Private respondent number 9, 12, 33, 35, 36, they are on 6/04/23 after us. Private respondent 18, 12/4/23 much after us. Private respondent number 3, 10, 21, 25, 02, 06, 23, much after us. Private respondent number 5, 7, 8, 15, 17, 23, 26, 20, they are 01, 06, 23, much after us. Private respondent number 13, 08, 06, 23, after us. Private respondent number 4, 28, 9, 6, 23, after us. Private respondent number 22, 12, 6, 23, after us. Private respondent number 29, 30, 31, 34, that is 29, 8, 23. Private respondent number 37, he is 1 day ahead of us, 19/1/23. Now I'll show the lordships that because that is relevant. Page NHB, page.
Respondent 37 is 15/5.
My lord, factually, I have done wrong. On the same date.
Oh,
19/1. Yes, same date. Same date with us.
Okay.
That is a clear typical mistake. Now I'll take lordship to NHB, page 28. Just to show how promotion order was issued with the effective date of regulation. Page 28, NHB. My lord, this is the regularization order dated 7 June 24, notification. In the interest of public service and on the recommendation of the Department Promotion Committee, DPC, communicated right letter number so dated 15/05/24. The Governor of Nagaland is pleased to regularize the officiating promotion in respect of the following officers under School Education Department as follows. Now, serial number, name of the officer, designation, then last on the right side, effective date of regulation in present post. This is material and this is important. On which date their services had been given promotion. So these are the effective dates. Now, lordship will see my name, petitioner's names. Petitioner's name. Page 34, running page 34. Serial number 181. Date of regulation is 19/01/2023. 82. Date of regulation 19/01/2023. So all the period 1 to 26 are the effective date of regulation is 19/01.
You're all at serial number 181 onwards.
181, 182, 184, 185, 187,
87.
then 189, 189, 190, 192, 194, 196, 197, 200, 201, 202, 203, 204, 205, 206, 207, 208, 209, 210, 212, 213, 214, 215. Yes, so these are the 26 petitioners who were regularized on the same date, that is 19/01/23. Then the name of the private respondents 3 to 37 in the repeat 3 to 37. 3 to 37. Their names start appear as serial number 54, page 30. 54, page 30, running page 30. The important part is date of regulation 20/01, 1 day after me.
Page 30.
Page 30. Page 30, serial number 54.
Hmm.
20/01, that is 1 day after me. Then coming down to 62, 20/01, date of regularization. Then serial number 69, 21/03, 2 days after me. Then page 31, serial number 78, 778, 20/01 after me. Then 93, 20/01, 2023. Then page 34, serial number 180. Page 34, serial number 180. Effective date of regulation is page 34, serial number 180. The effective date of regulation 20/01/2023. Then coming to page 35, serial number 195. 19/01, that is with me, on the same date with us. Then serial number 216. Coming to page 36, serial number 216. That is much after me. 06/04/23. Then 217, 06/04/23. Then 218, 12/04/23. Then 219, 05/04/23. Then 220, 06/04/23. 221, 06/04/23. 222, 06/04/23. 223, 05/04/23. Then serial number 225, 02/06/23. Then serial 226, date of regulation is 09/06/23. Then 227, 01/06/2023. Then 228, 01/06/23. 229, 01/06/23. 230, 02/06/23. 231, 08/09/23. 08/06, correction. Then 232, 01/06/2023. 233, 01/06/2023. Then 234, 01/06/23. 235, 02/06/23. 236, 1206, 23. 237, 0106, 223. 238, 0206, 23. 239, 0106, 232, 23. Then serial number 240, 0906, 23. Then 242, 2908, 23. 243, 2908, 23. Then 244, 2908, 23. Then 240, 245, 2908, 23. So by this regularization order, the effective date of regularization is all after us,
Except one.
except one with me. The rest were all after us. Now the rest, the newly implemented, they're all after us. They're all after us, If we go by the regulation order. So this is what I want to show to this honorable court. Now I'll come back to the paragraph, page 14, page 14, paragraph 6. That page 14, paragraph 6. That after the matter of promotion to the post of assistant headmaster junior grade 2 attain finality to be followed by fixation of seniority as per the provisions of the rules holding the field, namely Nagaland School Education Services Rule 2017. Suddenly, the government of Nagaland in the School Education Department has published the final seniority list of assistant headmaster white notification so that the 14/01/25 in the name of the commissioner secretary to the government of Nagaland, following the seniority position in the cadre of graduate teachers. Seniority in the grade of assistant headmaster was prepared based on the feeder grade graduate teachers without following their service rules. That's what I'm trying to show. While doing so, the said notification relating to final seniority list has not even obliged to refer to the relevant provisions of the said rules 2017, but has referred to a particular notification dated 08/03/2005, which has no relevancy. The chart given below will go to show how the private respondents have been illegally placed above the petitioner in the final seniority list published on 14/01/2025. Now, petitioners, this is the petitioners. I have shown here the effective date of regulation 19/01/2023. But in the seniority position, they have been shown 183, 184, 186, 187, 190, 192, 193, 95, 198, 201, 202, 205, 206, 207, 208, 209, 210, 211, 212, 213, 14, 15, 17, 218, 219, 220. And now on page 16, the private respondent number 3 to 30, 3 to 37. 3 to 37, though they are all regularized after us, I have shown the effective date of regulation here, but their seniority position are all above us. This is what I want to show. Lordship has understood. Now, I'll give the chart, the seniority chart I have prepared, so that it will be easy for the court to see. The seniority list of assistant headmaster as on 18/12/24 issued white notification dated 14/01/25. NHSC, page 38, name of the petitioners. I have shown now, I don't need to show this one. Now, the next page is
This is the.
done. Yes, this is what,
Notification.
yes, correct. Impugn notification. Now, private. Included, will include public content. What is it? When I. Just petition. My lord, then I have prepared another separately newly implemented group. I think I have, we have.
This one.
Yes, yeah. Now, though they were all after us, but their names, newly implemented people, seniority list of as on 18/12/24 issued white notification 14/01/2025. Nay, private respondents. These are the private response serial numbers, newly implemented parties. So now on the right side, serial number from the final seniority list as on 18/12/24. They are all serial number 1 above all of us up to down below the total total private respondent 155. So they are all above us in the impugned seniority list. This is what I have just prepared separately so that it not get confused.
So these are their seniority positions.
Correct.
in
As
the-
per the impugned
the impugned
impugned
seniority
seniority
list.
list. Now, my lord, I'll come back to writ petition, page 17, paragraph 7.
Yes.
Paragraph 7. That the petitioners beg to state that the said notification dated 14/01/25 put to challenge in this repetition is directly violative of the relevant provisions of the aforesaid rules of 2017 framed under Article 309 of the Constitution of India. 8. That the relevant provisions of the said rules 2017 inter alia provides for constitutions of service, gradation, and strand of service, method of recruitment, methodology of appointment, etc. Rule 13 speaks of DPC for promotion from a lower grade to a higher grade under Rule 6 for gazetted post and its relevant consideration. Laying down the rules of seniority, Rule 25 mandates fixation of seniority of the promotees. My lord, here, the Rule 25 prescribe two methods of maintaining seniority. One is for direct entry point, means graduate level. Entry point is graduate level. That is direct recruit. But in our case, promotees. Assistant headmaster post, promotional post. So therefore, Rule 25 maintain two separate provisions of law to maintain how to maintain seniority. So here we talk about our case is about promotees. Fixations. Rule 25 mandates fixation of seniority of the promotees, which provides that the seniority of promotees shall be determined in the order of preference or select list prepared by the committee. This is Rule 25, Clause 2 and Clause 3. I'll come to the rules after some times. For ready reference, the said rules order is Rule 25 is quoted below. Unquote, a quote, 25 seniority. One is, I have not added, one is directly for direct recruitment. 2 and 3 are relevant for the promotees. 2, the seniority of promotees shall be determined in the order of preference or select list prepared by the committee. Meaning, the meaning is, since assistant headmaster post is promotional post, DPC has to hold the meeting, and then after consideration of their case, they have to recommend. So in the recommendation, it should come in order of preference. Who should be regularized first? Who should not be regular later? In order of preference. That is what the rule talk about it. So, yes. 3, if the promotion of a member of the service is delayed on account of his failure to qualify all the conditions, he shall lose his benefit in the order of seniority vis-a-vis such of his junior who may be qualified earlier than him. This is the condition. Supposing my name is appear in order of preference ahead, but if I don't submit the documents in time, still I'll be placed below even my juniors. Paragraph 9. That the aforesaid provisions of the rules relating to fixations of seniority leaves no manner of doubt that the seniority of the petitioner vis-a-vis the private respondent is required to be fixed, maintaining the preference wise recommendation of the DPC as indicated in the order, in the said order, in the aforesaid NHB notification dated 07/06/2024 as indicated above and also explicit in the notification itself. Admittedly, the petitioner's effective date of promotion / regulation as assistant headmaster, junior grade 2 are prior in point of time than that of the petitioner private respondents, and accordingly, applying of provisions or tests of the above quarter Rule 25 of the Nagaland School Education Service Rule 2017, the petitioners are senior to the private respondents. Therefore, there cannot be any second opinion regarding these factual and legal positions. 10. That being aggrieved by the impugned action or notification dated 14/01/25, the petitioner have agitated their grievances by submitting their representative dated 12/02/25 to the Commissioner Secretary to the Government of Nagaland, Department of School Education, respondent number 2. 11. That while the petitioner were expecting a positive result on the basis of the representation dated 12/02/25, par contra, they have reliably learned that their representative has been rejected. On the other hand, steps are being taken for providing further promotion of the private respondents to next higher grade to the post of headmaster junior grade 1. 12. That if the aforesaid inaction of the official respondent is allowed to be materialized, the petitioners will suffer irreparable loss and injury. On the face of it, the proposed action of the official respondents to further harm the prospect of the petitioner is illegal and arbitrary, being contrary to the aforesaid provisions of Rule 25 of the Nagaland School Education Service Rule 2017. 13. That the petitioners submit that the particular reference made in impugned notification dated 14/01/25 by no stretch of imagination can override the provisions of the rules framed under Article 309 of the Constitution of India. If the impugned action is allowed to stand, the same will be violative of the mandatory provisions of the Rule 25 of the School Education Service Rule 2017. 14. That the petitioner submits that it is a settled legal position of law that the seniority of the incumbents in a service public cadre is always required to be fixed as per the provisions of the seniority prescribed under the rules, and the same cannot be diluted at the whims and caprices of the power that be. 15. That the petitioner begs to submit that the Rule 25 of the Nagaland School Education Rules 2017, having clearly mandated the particular manner in which the seniority of the promotees shall be determined, which is in order, quote, in order of preference or select list, prepared by the committee, unquote. The official respondent cannot flaunt with the said criteria and determine the seniority of the incumbents quite opposite to the said mandatory provisions. 16. That the petitioners beg to submit that the statutory provisions requiring to fix the seniority on the basis of preference wise recommendation of the
Okay,
DPC.
these are your submissions.
Yes,
from the-
so now,
Show
this is the
Rule
now
4025.
I'll show the rule. My lord, this is Nagaland School Education Department Rule 2017.
That same rules.
The same rules, which we used yesterday also. Now, my lord, from this is these prevailing rules framed under Article 309 of the Constitution of India. Now I'll take, my lord, page, the Constitution of the DPC, page 12. Page 12. Rule 12, we are not concerned with the rule because Rule 12 is for the non-gazette. Rule 12 talk about non-gazette. Then Rule 13 is relevant for us.
DPC.
DPC. Rule 13, Departmental Promotion Committee. All recruitment through promotion from a lower grade to the higher grade of the service under Rule 6 for gazetted posts shall be done through Departmental Promotion Committee consisting of the following members. This is NPSC Commission. Now, since our case, we fall under gazette post. So therefore, DPC was duly constituted in terms of Rule 13 by the state government. This is what I want to show. And it refers to Rule 6. Rule 6 talks about direct recruitment. Rule 13 refers to Rule 6. My lord, Rule 6 talks about direct recruit. Yes. So now, my lord, under Rule 13, the DPC was duly constituted by the government, and by this DPC, the case were considered for promotion or regularization. Now coming to the relevant rules, page 19, Rule 25, where it talks about seniority. Now under the rule, the seniority is governed by Rule 25. I'll just read out, my lord.
Yes.
Rule 25, seniority. 25(1). Seniority of members of the service recruited under Rule 6 shall be fixed in accordance with a merit list prepared. That is direct recruit. Merit list prepared by the commission/board, provided that if a person does not join service within 1 month from the date of issue of the offer of appointment, or within the period specified, or within the period of extended joining time allowed, he shall rank below those who join before him. So this is comes with direct recruitment, graduate entry point. Now our case is relevant here. Rule 25, sub-rule 2 and 3. Sub-rule 2. The seniority of promotees shall be determined in the order of preference or select list prepared by the committee. So now, whenever DPC is held for promotion, to consider promotion, the always DPC always held, examine their matter, all the relevant documents, files, record, SCR, including SCR, everything. After due consideration, the DPC will recommend in order of preference. In order of preference. So based on that, in order of preference, seniority shall be prepared for the promotees. Rule 25, clause 2. Clause 3. If the promotion of a member of the service is delayed on account of his failure to qualify all the conditions, he shall lose his benefit in order of seniority vis-a-vis such of his juniors who may be qualified earlier than him. Now, when I inquire, what does this mean? They say, supposing if a person's name, candidate's name appeared ahead of Mr. B in order of preference, but still, if he doesn't qualify to submit all the document demanded, like my for earlier appointment, my everything, then in that case also, he will lose the senior position. This is what the minister. So now these are the relevant provisions of law. We are only concerned about seniority in the present case now. So now, therefore, the facts are limited. The questions, the issues, the issues to be decided in this case is, according to me, the issues to be decided in this case is, number 1, whether the seniority dispute relates to promotees. Issue number 1, whether the seniority dispute relates to promotees. If this is determined, and that will be bound by service rules. Then next issue, which this court need to decide, is whether the post of assistant headmaster is a promotional post. Whether the post of assistant headmaster is a promotional post. Then third is whether there was any selection conducted through DPC. Whether there was any selection conducted through DPC. Because Rule 25 talk about selection through DPC and recommend in order of preference.
Select list
Correct.
prepared by DPC.
Then issue number 4, according to me, whether DPC's recommendation dated 15/05/24, whether the DPC recommendation dated 15/05/24 and the regularization order dated 2024 are under challenge.
Seven, six.
Are under challenge or not? If that is not challenge, that is the issue now. Now, in this case, nobody has come forward to challenge this recommendation as well as the regularization order. Now, next issue is 5 is whether service rules 2017 governs the seniority of the promotees. Whether service rules 2017 governs the seniority of the promotees. And if it is yes, we are governed by the rule. Then last issue that this court need to decide is whether the final seniority list published on 14/01/25 is violative of relevant rule 25 of rules 27. I repeat, whether the final seniority list published on 14/01/2025 is violative of relevant rule 25 of rules 2017. So according to me, in my humble submission, if these issues are decided by this honorable court, then the present case will be decided on these issues. Judgment given. My lord, I'll just come to the law judgment in support of my contention. I have supplied the
This list.
just principle, I'm just reading out. On the question of primacy of statutory provision, meaning Supreme Court says, what Supreme Court says about the rule. If there is service rule, no statutory law, no resolution, nothing can overrule. This is Air 1985 SEC Supreme Court judgment. The principle is in HV Pardasani versus Union of India held. There is no dispute that in the absence of any special provision regulating determination of seniority, length of continuous service in any particular grade would be the basis for determining seniority in that grade. Grade, my lord, grade is important. The legal position is equally settled that if a rule prescribes a method of fixation of inter-se seniority, the normal practice would not apply and the rule shall prevail, obviously subject to the constitutionality. This is paragraph 6. So now, if there is no service rule which governs seniority, yes, notification, all these practices will prevail. But when there is already rule govern the seniority, the legal position is this, my lord. The next case, the Ashok, this is Supreme Court judgment, Ashok Ram Parhat and other versus state of Maharashtra, reported in 2023. Paragraph 25, held in service jurisprudence, the service rules are liable to prevail. There can be government resolutions being in consonance with or expounding the rules, but not in conflict with the same. Government notification rule cannot go against the statutory rules. Then next 3. This is in the case of Amit Singh versus Ravindra Nath Pandey, paragraph 20, 20 sub reproduction, unquote, 45(2). Inter-se seniority in a particular service has to be determined as per the service rules, unquote. Paragraph 21. This court further held that the inter-se seniority in the particular service has to be determined as per the service rules, not otherwise. Then 4. Supreme Court, Ganga Vishan Gujarati and others versus state of Rajasthan, held a consistent line of precedent of this court, meaning Supreme Court, follows the principle that retrospective seniority cannot be granted to an employee from a date when the employee was not born on a cadre. Seniority amongst members of the same cadre has to be counted from the date of initial entry into the cadre. In the, my lord, here, just for a short time. In the present case, my lord, the private respondents joined were promoted after me in the grade of assistant headmaster. They might be senior in the graduate teacher, but when selection comes, selection was done by the DPC. So as per the recommendation, we are ahead of all of them. So now therefore Supreme Court says for that particular grade, for a particular grade, the seniority shall be maintained from the date a person was born into that grade. Born into that grade, assistant headmaster grade. So there I was born ahead of them. Now the most relevant, that's why I have given lengthy the last citation. This squarely cover our case now. Year 1968, SK, sorry, SK Ghosh and another versus Union of India. This is Supreme Court. Paragraph 8 held. This rule also makes it clear that appointment to the grade of directors of postal services is made by selection, my lord, DPC through by selection, and not on the basis of promotion in accordance with seniority. The presumption exists that the promotion of the petitioners and the private respondent 3 to 7 of the grade of director must have been made in accordance with these instructions and rules, so that the appointment of all these concerned parties as directors was based on merit to be taken into account at the time of selection and not on seniority in the time scale of class 1 service, lower grade. Once a member of class 1 service in the time scale was selected for promotion to the grade of director and given seniority over another officer, selected later, the seniority so determined as a result of selection could not be made dependent on the seniority in time scale. Feeder grade, seniority from the feeder grade cannot be the criteria to consider, to decide the seniority when it comes to selection. When it comes to selection. My lord will appreciate. This is not normal promotion. Supposing if it is normal promotion, all of us were all regularized official in the same grade. Then we follow the seniority position. Then in that case, of all the one by one regular promotion. But in our case, DPC selection. Selection was held.
They were senior in the grade of graduate teacher.
Yes. So now this Supreme Court says that even if private respondents were senior in the lower grade, in case of selection conducted by DPC or any promotional committee, in that case, in that higher grade, whoever were senior, their seniority will be maintained. Now, the case of the private respondents is this. To sum up, the case of president is we were senior in graduate teacher, entry point. So therefore, there should be continuity of the seniority. Number two, they are saying, look, in the past, in the grade of graduate teacher, there was a seniority dispute. So High Court has held that it should be go as part of the seniority of direct entry point. Their case. Now, all this judgment went to show that the seniority of a particular grade shall be determined on the day a person was born. Yes. And now, in the present case, the existing service rules, as I have read out the relevant rule 25, clearly mandated that the seniority of the promotees shall be determined in order of preference or select list. Now, what is that order of preference? DPC, in our case, DPC recommended, they have annexed. DPC recommendation shows that petitioners were regularized or promoted ahead of prior to their regulation. Prior to their regulation. That is the order of preference. And that fact they cannot deny, because That's why they cannot deny, number one. Number two, they have not challenged the recommendation. They are simply saying it is erroneous. They have not challenged the formal regulation order, promotion order of 0706/2020. Regulation order. 0706/2024.
Which one is that?
Regulation order. NHR B to my read petition, page 28. Now, my lordship will appreciate, unless this regulation order is set aside, unless this regulation order is put to test, unless this regulation is under challenge and set aside by a competent court, this regulation order will remain. And so as long as the regulation order remains, 0706/24 remains, then that position cannot be unsettled. That position cannot be unsettled. In the present case, the impugned seniority list was not prepared in terms of the regulation order, where the regulation order was issued with a condition. What is that condition? Condition showing the different date of regulation. The condition that showing the different date of regulation for all of us. And all of us have accepted that one. Nobody has challenged this regulation order. Nobody has challenged the DPC minutes. So in that case,
DPC minutes are annexed.
yes, it's there. They have annexed also.
Oh, okay.
They have annexed. So now, in the absence of any challenge, when the formal regulation order showing that date of regulation order, date of regulation is not under challenge, then how can the department issue the impugned seniority list contrary to the regulation order, where the date of regulation is shown that petitioners are senior, they were regularized ahead of private respondent. Then, coming back to the same point, this, going by the service rule, this is the regulation order in order of preference issued by the DPC. Rule 25 is very clear that the seniority of the promotees shall be on the basis of the in order of preference issued or prepared by the DPC. So therefore, in the present case, the seniority list issued by the department, keeping us down below the private respondent who were regularized after us, is bad in law, is illegal. Therefore, in my respectful submission, it cannot stand the test of law. So therefore,
Where is the impugned seniority list in your petition?
yeah, yes.
Which
Senior.
annexure? Annexure
Senior.
C.
NHS C. Page 38, madam.
38.
Page 38. Page 38 till page 48. This is the impugned seniority list. So the recommendation, the regulation order are in line with Rule 25. And if we go by Rule 25, then the impugned seniority list is contrary to Rule 25. And if it is contrary to Rule 25, the judicial pronouncement of Supreme Court is very clear that rule will prevail. Notification will not prevail. This is mandatory provision, my lord. So therefore, in my respectful submissions, this petition should be allowed and direct the department, direct government to prepare a seniority list in terms of that regulation order and DPC minutes. That much of it.
Yes, government.
May I please, my lord?
Lordship, the
Respondent 1 and 2.
yes, my lord. To start with, my lord, the petitioners and the private respondents, there was a seniority dispute earlier, which they have approached this honorable court, and this honorable court has directed the respondent department to bring out a final seniority list. Basing on the judgment of this honorable court, the final seniority list of 2022 has been prepared, where the petitioners are actually placed junior to the private respondent, Your Lordship. Now, Your Lordship, the reason why the petitioner today is challenging the seniority list, tentative seniority list, which is impugned in this present writ petition.
This
The final
14
seniority,
25
yes,
is
yes,
final.
yes. Final seniority list, which is impugned in this writ petition, is for the fact that this final seniority list will lead them to the next promotion. That is the reason why they're disputing it. And that is the reason why they're challenging it. If that is so, Your Lordship, the list of 2022 is the reason how the petitioners as well as the private respondents were given officiating promotion. They were not given just like that. So the next day, the below grade seniority list is taken for the next promotion. That is the reason why the petitioners are impugning. Impugning the seniority list dated 18/12/2024.
So that seniority list, which was issued on the basis of the court's order,
Yes,
was prepared in the cadre of graduate teachers.
graduate teacher, correct. And because they were placed in a graduate teacher, they were given the officiating promotions of the assistant headmaster. Yes, AHM. Now, the next line of promotion is, Your Lordship, the headmaster as per the service rule. Now, Your Lordship, the officiating promotions of the petitioner to the post of AHM, Your Lordship, my learned senior friend has already read it out, which is at page 24 of the writ petition. As far as the private respondent officiating promotions are concerned, Your Lordship, I have annexed it at page 160, annexure D of my affidavit in opposition, my lord. Starting from page 160, my lord. So this is the officiating promotion dated 21st of March, 2023. The first.
This is officiating promotion of
Yes, of
private respondents.
Yes, yes. Then, Your Lordship, page 161. Not all, Your Lordship, there are various officiating promotion. Page 161. This is another officiating promotion given to some of the private respondent by order dated, notification dated 5th of April, 2023. Your Lordship, by another notification at page 162, notifications dated 31st of May, 2023,
Another batch of private respondents has been given officiating promotion to the post of assistant headmaster. Then likewise, Your Lordship, by another notification, 25th of August 2023, which is at page 163, Your Lordship. Some of the private respondents were again given officiating promotion. Now, why different officiating promotion was given on a different date, Your Lordship, is for the fact that the documents that the department has been collecting to give them officiating promotion was received on different dates. This is the reason why. This is the reason why different notifications was issued to give them officiating promotion on a different date through a different notifications. Of course, it has been done on the same year. That is 2023. Now, Your Lordship, the petitioner are claiming now to be senior than the private respondent, basing on the DPC recommendations on 7th of June 2024. And this DPC recommendation, if you see, Your Lordship, on the last column, effective date of regularization on the present post. This, Your Lordship, will find it at page 28. Yes, effective date. If you see the effective date, Your Lordship, this is a date next to the notification that was published where the names of the petitioners and the private respondents are there. The petitioners was given officiating promotions on 18th of 2023, and therefore the effective date of regularization was given as 19th 2023. Likewise, Your Lordship, the private respondents were given in the remarks, effective date of the private respondents were given as 21/3, 6/4, 26/4, 15/4, so on and so forth, my lord. Now, Your Lordship, I wanted to point out one thing here, my lord. Before the DPC set, Your Lordship, the petitioner knew that they were junior to the private respondents. They have not disputed the final seniority list at all, at any given point of time. They have not disputed the final seniority list. Then after that, Your Lordship, officiating promotion was given on a different date. There is no dispute to that also, Your Lordship. However, after the officiating promotion was given, as I said, Your Lordship, officiating promotion was given on different date because of the submission of the documents on different timings and different dates. That is how even the officiating promotion was given on different dates. However, since the notifications, some of the private respondents were already given officiating permission after the petitioner has been promoted, given the officiating promotion. To rectify that, Your Lordship, the government has brought out a notification, Your Lordship, dated 2nd of May 2024. Your Lordship will find it at page 164 of my affidavit in opposition. At page 164, my lord. Your Lordship, this notification is important, so allow me to read it, my lord.
Yes, what did it say?
Yes, Your Lordship. I may be allowed to read this, Lordship. Notifications dated 2nd of May 2024. In continuation, Your Lordship, in continuation of to this department notifications dated 18/1/2023. Your Lordship, 18/1/2023 is the notification pertaining to the officiating promotion of the petitioner.
Yes, yes, petitioner's promotion.
Yes. And dated 21/3/2023. Notifications dated 31/5/2023 and 28/8/2023 and notifications dated 13/9/2023. These all are the notifications through which the private respondents were given officiating promotion. Yes. The first one relates to the petitioner, the rest, Your Lordship, to the private respondents.
So 18/1/23 petitioners officiating
Yes,
promotion to
yes.
AHM.
Yes,
Including private respondents, Lordship.
including some of the private, yes, some of the private, yes,
Maybe one or
Backline.
two.
yes,
Ah.
yes, one or two. So it says, Your Lordship,
Petitioner and then respondent number
6, 11, 16,
6, 11, 16,
19, 32.
19 and 32,
Yes, we were promoted along with the.
along with the petitioner.
Yes.
Then the rest of the respondents on 31/5, 28/8 and 13/9.
yes, Your Lordship. And it says, Your Lordship, the grant of officiating promotion in respects of the graduate teacher to that of assistant headmaster will be subject to the following conditions. The officiating promotion shall not confer any right for claim of seniority other than as notified in the undisputed seniority list of 2022. Now, Your Lordship, even though officiating promotion was given on different dates, and the petitioner was given officiating promotion before the private respondents, yet by these notifications, it clearly says that the officiating promotion shall not confer any right for claim of seniority other than as it is notified in the undisputed seniority list of 2022. So this notification is upholding the seniority list of 2022, my lord.
And in that earlier writ petition, all the respondents and the petitioners were parties.
Yes. Now, Your Lordship, this notification was issued prior to the sitting of the DPC. This notification was not challenged, my lord. This has been issued on 2nd of May, 2024. The DPC said, my lord,
15/5.
on 15th of 15/5/2024, my lord. 15/5/2024. It was already there, Your Lordship. I also wanted to point out one thing here, Your Lordship. If you see at the bottom part, copy 2, number 9, officers concerned. The petitioner is well aware of this notification. They have not challenged it. They have not challenged it in any way, Your Lordship. And even up to today, this notification still stand. And why the final seniority list, Your Lordship? How the final seniority list of 18/12/2024 has been prepared, it is basing on this particular notification, Your Lordship. I'll come to that later on, Your Lordship. Now, your lordship. The service rule, my learned senior friend has read it out. The service rule. I would like to, your lordship, take my lordship to Rule 13. Rule 13, clause 3, subclause B. Your lordship will find that at page 13 of the service rule.
13(3)
B.
B.
Yes, my lord. It says, if I may be allowed to read this, my lord. A list of eligible official to be considered for promotion or placement along with the latest seniority list. What is to be submitted is placed at 3. It says, along with the list, the department shall prepare and send the following papers document to the chairman and members of the DPC. And 3B says, a list of eligible officials to be considered for promotion, placement, along with the latest seniority list. So seniority list will be counted, your lordship. Will have to be considered when it comes to DPC. And what is that seniority list, your lordship? It is the list, undisputed seniority list of 2022, which is the graduate teacher. In order, your lordship, your lordship, in order to be born into a cadet, how will a person be born into that cadet, your lordship? A person has to be born into that cadet through a DPC or through a direct recruitment. We are concerned with the DPC. And how would the DPC allow that person to be promoted and born into that cadet? Is it not on the basis of a seniority, your lordship? And therefore, 3B says, a list of eligible officers to be considered for promotion or placement along with the seniority list has to be submitted before the DPC.
What reasoning has the DPC given?
Nothing, your lordship. Nothing. More so, your lordship. I'll take my lordship to Section 13, same rules, your lordship. Rule 13(3), 5, subclause 5. And it says, your lordship, whenever a junior candidate is recommended for promotion in preference to a senior one, the committee shall report in writing the reason for doing so. Your lordship, in the DPC, no recommendation as such has been
That's why
made.
I was asking,
Yes.
because DPC has to record the reasons.
Yes. No recommendation as such has been made. And if there is no recommendation, your lordship, the list of 2022 was the reason as to how, your lordship, the seniority has to be maintained. This is not disputed, your lordship, at all, at any point of time. This has not been disputed. Even when the notification saying that the officiating promotion cannot be considered for seniority, the petitioner did not come forward challenging that, meaning thereby they have accepted it, your lordship. Now, your lordship, by the notifications dated 14th of January 2025, the final seniority list was prepared, which is under challenge. Your lordship will find that at page 38. Of the repetition, sorry, my lord.
Yes.
Allow me to read this, my lord.
Notifications dated 14th of January 2025. The final seniority list of assistant headmaster under elementary and secondary cadres of school education department as on 18/12/2024 is hereby notified with the following principles, criteria, and conditions, Your Lordship. 1. AHM at serial number 7, 18, and 19 are the SIS upgraded as GEO AHMS AEOS issued via department notifications dated 8/3/2025. The placement of these three AHMs is as per the conditions stipulated in the cited notifications. Extract of the notification, Your Lordship. Extract of the notifications, subject to the conditions that this will not confer on them any right to claim seniority over their seniors in the common seniority list, while being considered for further promotion to the post of headmaster. In other words, they shall hold the post in gazetted status, but they shall deem to have not superseded the other SIS graduate teachers who were otherwise senior to them in the inter-se seniority list of graduate teacher. This is basing on that notifications that I have read it out, my lord. Now, before this final seniority list was prepared, Your Lordship, it was sent to the PNR department, and the views of the PNR department can be seen at para 2. Your Lordship. And it says that the school education department is advised to maintain the seniority of AHM JU as per the seniority in the undisputed seniority list of graduate teachers of 2022 for the incumbent AHM and JUs. Now, Your Lordship, against these particular notifications and seniority list, the petitioner, as stated by them, has submitted a representation, Your Lordship, which Your Lordship will find it at page 49. Of the writ petition. And this representation has been disposed of, Your Lordship, has been disposed of by the School Education Department on dated 11th of March 2023, which Your Lordship will find it at page 165 of my affidavit in opposition, my lord. Your Lordship, I may be allowed to read this, Your Lordship. This is a letter dated 11th of March 2025, reply to the representation in respect of the final seniority list of the assistant headmaster. Sir, I am directed to refer to a representation dated 12/12/2025 on the subject cited above and to state that your representations for rectifications and restorations of final seniority list of assistant headmasters in terms of the Nagaland School Education Service Rule 2017 was referred to PNR for re-examinations. PNR department via your number dated 28/2/25 has furnished the following observations which are reproduced below for your information. I'll read only the relevant para, Your Lordship. Para 1. Under the established procedures, promotions are granted to the employees on the basis of the seniority cum merit. Whereas in the instant case, officiating promotions were granted to the officials on various occasions based on the availability of the requisite documents while granting officiating promotions. 2. Incidentally, the officiating promotions of some senior graduate teachers were denied promotion due to non-availability of the requisite documents at the time of examinations with no fault of the employees, as all requisite documents of the employees shall be under the custody of the appointing authority. 4. However, among the same group of promotees, the date of taking charge by an officer appears to have been taken on a different date, which would create a scenario where a person who have taken charge early may have advantage over their fellow promotees in the seniority position. 5. Further, the undisputed seniority list of graduate teachers 2022 was prepared based on the judgment of this honorable court in Read Appeal 17K of 2017 and Read Appeal 16K of 2017, dated 12/12/2019. As such, any selection based on the availability of documents would deprive the most deserving employees in the zone of promotion. 7. Furthermore, the school education department are requested to ensure that all requisite details of the employees along with valid documents are satisfied before the matter is submitted to the PNR department for consideration. Your Lordship. This representation is also not under challenge, my lord. The reply, sorry, madam. The reply to the representation, Your Lordship. Has also not been challenged. Lord. At the end of my submission, Your Lordship, I would like to take my lordship to Rule 25 of the seniority of the Rule 25, which relates to the seniority. Your Lordship will find that at page 19. Page 19, madam. Rule 25 seniority. I'm concerned with Your Lordship, Rule 25(4). If I may be allowed to read this, my lord. Seniority. 4. Supersession of one officer by another having the effect on the interstate seniority of the affected officers can take place only with the specific recommendations of the DPC, which shall also mention the reason for recommending such supersession.
This is what I was.
Yes. Now it is going to affect the interstate seniority, Your Lordship. So this can be done only when the DPC makes a recommendation, makes a specific recommendations, not,
And records the reason.
yes, and records the reason. There's nothing like that, Your Lordship, here in this case. And therefore, the list of 2022 seniority has to be maintained, Your Lordship, as far as the assistant headmaster's promotion post is concerned, Your Lordship. I am obliged, my lord.
May I please, Lordship. Lordship, I may bring for respondent number 26 of 10. 3, 4, 5, 7, 8, 9, 10, 12, 13, 14, 15, 17, 18, 20, 21, 22, 23, 24, 25, 27, 28, 30, 31, 34, 35, and 36. 31, 34, 35, and 36.
21, 24, 25, 26.
36. In the present rate petition, since the seniority list has been, final seniority list has been under challenge, Lordship, here I'm not going to facts. Lordship, the petitioner just solely relying on Rule 25 Clause 2 of the rules of 2017. Lordship, the list, the recommendation of the DPC, as your Lordship has also rightly pointed out, in terms of Rule 13(4), Roman 4. Rule 13, Roman 4.
Rule 13 is the DPC.
Yes, Lordship. Constitution of the DPC in its function, Lordship. 13(4) says, Lordship, in the bottom, Lordship, whenever a junior candidate is recommended for promotion in preference to a senior one, the committee shall record
1 minute, 13.
13(4).
13.
No, 13(5), Lordship. Sorry, I'm sorry.
No.
13 clause 5, Lordship. 13(5). Lordship, in the present case, Lordship, the seniority list of graduate teacher of 2022 that was finalized on the basis of a direction passed by this rule. That is not disputed by the petitioner. So in the present case, as per the recommendation of the present recommendation of the DPC, the petitioners who are junior to us, they were given an effective tier of regularization ahead of us. If that is the case, and if that has to be accessed by the DPC, they have to record a reason as per this provision. Similarly, Lordship, and under Rule 25, Rule 25, Clause 4, also give the prescribe the same provision. Lordship. Rule 25, Clause 4. Just not my learned friend read out, Lordship. That is. But here it clearly mentioned, Lordship, supersession of one officer by another, having the effect on the interstate seniority. Lordship, having the effect on the interstate seniority. The interstate seniority in the cadre of graduate teacher. That is the final seniority list of 2022. So that if that has to be affected, the DPC has to give a specific recommendation. If we see the DPC recommendation, Lordship, that recommendation is not yet. And Lordship, the present case issue involved is for the promotion of assistant headmaster. Issue for the promotion of assistant headmaster, it is prescribed under Schedule 2 of the rules of 2017. Lordship, we come to page number 29. Assistant headmaster concerned with it comes under clause 7. the mode of recruitment is, Lordship, 80% by promotion and 20% by departmental examination. We are concerned with 80% by promotion in the present case. So, Lordship, if we come to the extreme right side, A, promotion.
Yes.
The post of assistant headmasters, GU, that is, shall be filled by promotion on the recommendation of the committee. This is important. Selection shall be made from among the confirmed senior graduate teacher, senior legal assistant, provided that he has completed at least 7 years of senior graduate teachers, senior legal assistant. Lordship, it speaks about selection shall be made from among the confirmed senior graduate teacher. Confirmed senior graduate teacher, it will be determined only on the basis of updated final seniority list. That is the seniority seniority list of 2022. If we go by this provision, the provision of this rule, giving officiating promotion, that is a material. The DPC has to take into consideration the seniority list of graduate teacher, of the confirmed senior list teacher. That was not taken into consideration by the DPC at its sitting. And if, after taking into consideration of such seniority list, if an issue arises for supersession, the TPC has to give its recommendation, but that is not there in the present TPC recommendation. I will ship the TPC recommendation. I file an affidavit on behalf of the private respondent.
I need affidavit, so date.
Yes, there is date of filing
Affidavit in opposition filed
of respondent number 3457.
8 May 2025.
Yes, 85%. Lordship, the petitioner has not annexed the recommendation of the DPC in the writ petition. Lordship, the kindly come to annexure 1, page 11. Lordship, as my learned friend, the counsel for the petitioner, he has already pointed out the date of recommendation for effective date of regulation. Lordship, that I am not repeating. Lordship, I'll take your Lordship only to the decision-making process of the DPC in giving their effective date of regulation. Lordship, we come to page number 23.
Page 23.
Page number 23. This is a note, the only note which the DPC has given in your recommendation. Regarding the supersession, it's silent. But your decision-making process in giving the effective date of regulation, Lordship. Lordship got it? Just below the box. Note. In view of the notification number so and so, dated 2/5/2024. This is the basis, Lordship. The basis of your decision. The DPC decided to regularize the officiating promotion of assistant headmaster as per their date of training. This is the basis of your decision-making process. Lordship,
Okay, so this 2/5/23.
yes, Lordship, that is the Lordship. Come to page number 24. The next page.
Actually, yes, that the one which the government advocate.
Yes, the government advocates just point out. Lordship, this notification says that the seniority has to be notified. The promotion shall not, Lordship, page number 24. I'm not reading the terms and condition. The only condition laid down in this notification is the official information shall not confer any right for claim of seniority other than as notified in the undisputed seniority list of 2022. Your Lordship, the DBC has quoted this notification. This notification says that seniority has to be as per the undisputed seniority list of 2022. But see that your decision-making process and the petitioners, the petitioners, they want to resort to clause 2 of Rule 22. The preference, the list of preference given by the DBC.
Yes. Select list and preference list.
Yes,
is
okay.
it? Mm.
So the recommendation of the DBC suffers from gross irregularities. Your Lordship, without prejudice to both the parties, the petitioner as well as respondent, in my respectful submission, a fresh DBC is called. The petitioners, they cannot rely and they cannot base a claim on this defective DBC recommendation. My submission is on 2 reasons. Based on Rule 13+4 and 25+4. No reason has been recorded in case of supposition. And the decision making of the DBC. This is totally contrary to the records, which they've made, they've placed here. That's all, Lordship.
This Lordship.
Yes.
Lordship, I'm representing respond number 6, 11, 16, 19, and 32. Lordship, my case would be different from the other brother respondents because we were promoted by a different order before the other brother respondents were promoted to the post of AHM. In other words, Lordship, there are 3 categories of brother respondent here in this petition, Lordship. We were promoted along with the writ petitioner on 18/1/2023 to the post of AHM.
Promoted on the same day, on
Same day,
18/1/2023.
1/23. The other brother respondents up to 37th, whom my little friend Wabang is appearing, they were promoted after our promotion, although on overshooting. And the other brother respondents, newly employed respondents, they all are, most of them are junior to me, Lordship. And although they were employed as a new respondents in the writ petition, no amendment, nothing has been done in the writ petition. No grievances at all, Lordship. No amendment in the prayer, no amendment in the pleadings. It should be done, in fact, Lordship, which was not done by the writ petition.
After the newly implemented.
No amendment, nothing, Lordship. No grievances at all against the respondent number 38 to 155 in the writ petition. No grievances in the writ petition against those respondents. That is why I'm submitting to the 3 categories of respondent and this writ petition. Lordship, my submission will confine to the roles which my learned friends, petitioner, as well as the brother respondents, government advocate have referred to. Lordship, dispute is with regard to assistant headmaster. Therefore, Lordship, it is important, it is become important to examine how the post of head assistant headmaster has been filled up by officiating promotion. From where? The all are promoted from the boss of graduate teachers. Do assistant headmaster. That becomes relevant, Lordship. As procedural to just now, my learner friend has referred to. The boss of assistant headmaster should be filled up by senior graduate teachers or the graduate teachers. Therefore, Lordship, all the promotions, the petitioner and the private respondent I'm representing and the other private respondents were promoted as per the seniority position of graduate teachers published in 2022. Lordship may kindly come to government affidavit. Government have annexed the seniority list of 2022, which page 91 of the government affidavit, Lordship.
Yes, starting from 92.
Yes, Lordship. Lordship, me kindly come to serial number 219, page 98. Two 119, Lordship. Respondent number 6. 249. Respondent number 11. Next page. 287. 287. Respondent 16. Respondent number 16. Serial number 329. Respondent number 19. And serial number 605, page 110. Page 110, Lordship. 605. Respondent number 32. Now the name of the petitioner starts from 616. This is the petitioner number 1. 616, Lordship. Anungla Bunginer. That is the petitioner number 1. And all the petitioners' names record after
this.
616, Lordship. Therefore, Lordship, as per the seniority list of graduate teacher 2022, the promotion was made to the post of AHM. And as per the seniority list, we are much senior writ petitioner. Now come to the writ petition, page 24 of shooting promotion.
Page
24. That is burden, Lordship. Notification dated 18/1/2023. This, in the set of promotion of the Lordship, the names has been reflected in terms of the seniority, Lordship, in terms of the seniority of 2022. Serial number 56, page 24.
This is promotion to AHM.
AHM, Lordship. dated 18/1/2023. Roll number 56. Next page, Lordship. Is R6, 64 R11, 79 R16, 94 R19,
90.
4 R19, next page 183 R32,
183.
183. The petitioner starts from 184.
184.
This notification by which the petitioner as well as the private respondent, I'm representing Lordship, were given permission. We received this notification on 19/1/2020, which was issued on 18th. And we have given our joining report on 20/1/2023. Joining report given on 21/2023, Lordship. This will be relevant after some time, Lordship. Why I'm submitting about my joining report, Lordship. Lordship, may kindly come to my affidavits filed on 6/5/2025. Mr. Lordship, got it? Page 31, my learner friend has also referred to, but Lordship, I'm also relying. DBC, Lordship, minus subject. This is forwarding letter by the NBC. And next page 32. This is the meeting minutes, Lordship. Recommendation of the DBC. Lordship, may kindly come to page 35. Serial number 54 is R6. 62 is R11. 78 R16. 93 R19. And 180, page 40, 40, Lordship. And serial number 180. R32. The name of the petitioner starts from 181. Lordship, there is no dispute that the DBC have given the effective date of regularization in respect of the present respondents from 2021 to 2024.
21/23.
23. And in respect of the writ petitioner, effective date is 19/1/2023. Why, Lordship? I have submitted my training report on 21/2023. Because I've received the officiating promotion on 19th. Therefore, I've submitted only on 21/2023. But my submission, Lordship, my submission is effective date of my submission is effective date of recolorization of the overseeing promotion given by the DBC is irrelevant, Lordship. My submission is, it is irrelevant. On two grounds. First ground, Lordship, Rule 13 of the service rule doesn't empower the DBC for fixation of seniority. To give effective date of regularization, Rule 13 of the service rule up to 17. And now the petitioner is banking on the effective date, Lordship. Kindly come to Rule 25, provision of Rule 25 Clause 2. Rule 25 Clause 2.
Yes, petitioner is relying on this.
Yes,
25
I'm also supporting this role, Lordship. Clause 2. I'm not reading the other clause, Lordship, because others are not relevant. Seniority of the promotees shall be determined in order of preference, Lordship. An order of preference or the select list prepared by the committee. Lordship, come to DBC. Can you see the preference and the list? As your Lordship got it? DBC.
DBC minutes.
Yes. Order of preference and the select list. What is the list? Our names is reflected up to serial number 180 as per the list, Lordship. As per the list. I'm not talking about effective date of regularization because Rule 25 of the rules doesn't provide about the counting determination of seniority from the effective date given by the DBC. So, as per the list and the order of preference of the DBC, Lordship, we are much senior. Your names are below us, Lordship, from serial number 81. Therefore, interpretation of this role is become, Lordship, necessary. What is meant by order of preference or the list? List is already provided by the DBC, Lordship. Where are names reflected above the read petitioner? So that is the order of preference in the list, according to my interpretation, Lordship. Lordship, sorry?
The
Therefore,
names
Lordship,
of the petitioners here in the DPC list figures from serial number.
serial number, Lordship, serial number 54, 62,
No, the petitioners.
petitioners,
Mm.
Lordship, from serial number 181. Srimati Anung Labung Manor. 181. That is in order of preference and the select list of the DBC, Lordship. Now the petitioner is bringing on the effective date of regularization, which rule doesn't provide for. Rule doesn't provide. To determine the interested seniority from the effective date of regularization given by the DBC. That is why I'm raising again, Lordship. DBC has not been empowered by the role to determine the effective date of regularization. Bida Tasime, Lordship, come to page 42. The reason, Lordship.
42 of. Oh, yeah,
43
the
of my
DPC.
affidavit is, Lordship. My letter pen also.
That we have seen. They have only relied on the 2/5/24 notification.
Lordship.
As per their date of joining.
Page 43, Lordship.
Yes.
Note column.
Mm.
Maliner friend also read out.
Yes.
In view of the notification that is so 2/5/2024, the DBC decided to regularize the officialing promotion of assistant headmaster as per their date of joining. I made a submission that I joined on 21/20/23. This effective date of regularization given by the DBC is not for determination of seniority, Lordship. It is clear from this note, Lordship. It is not for determination of interest seniority of the assistant headmaster, Lordship. The DBC has been constituted in terms of Rule 13, provisions of Rule 13 of the Service Rule of 2017 to regularize the officialing promotion, not for determination of seniority, not for fixation of the date of regularization, Lordship. That is how the DBC have given the reason in the note column, Lordship. In view of the office notification dated 2/5/2024. That is the reason given by the DBC. I've raised some preliminary objection in the petition, in the affidavit of opposition, that the petitioner have not challenged the DBC, the regularization order, and the notification of 2/5/2024. Now they are again making a submission that nobody challenged the mandates of the DBC and regularization order, which I've already made as a preliminary objection, because it is not us to challenge the DBC, because DBC and the regularization order is in my favor, Lordship. Because as per the list and the preference, we are senior. Therefore, why should we challenge? And this DBC, Lordship, this mandates of the DBC, the notification of 25/2024 are not brought to notice of this honorable court by the writ petitioner. Therefore, I raised the objection with regard to suppression of material facts as well, Lordship.
That's why from the very beginning, I was asking for the DBC minutes.
Yes, Lordship. Lordship, will kindly come
That is-
by
that is
affidavit,
important.
Lordship.
Which affidavit?
My affidavit, Lordship.
Oh,
Page 9, Lordship. Bara 3, may I read, Lordship. That without prejudice to the amendments made in this affidavit, this deponent beg to raise preliminary objection with regard to maintainability of the writ petition on the following grounds. Number 8. The sole challenge made in the writ petition is the ambient final seniority list of AHM issued by notification dated 14/1/2025 on the ground that petitioners are senior to the present paper respondents in terms of the effective date of regularization and the boards of AHM. The industry seniority of AHM has been fixed by the ambient seniority list, this important, Lordship, in terms of notification dated 2/5/2024, recommendation of DBC dated 15/5/2024, and notification dated 7/6/2024. That is the regulation note, Lordship, 7/6/24. However, neither the recommendation of the DBC nor the regularization order dated 7/6/2024, wherein the names of the present respondents are above the writ petitioners, are under challenge in the writ petition. It is settled principle of law that challenging the consequential orders without challenging the basic orders is not permissible under the law. The writ petition is therefore not maintainable and deserve to be dismissed. Lordship, I'm relying on due judgment on the principle of challenging the consequential orders without challenging the basic order is not maintainable, Lordship. Two 2010. One ECC. Page 417, Lordship. 2001.
2010,
One ECC
yes.
417, Lordship. I'll rely only on one paragraph, short paragraph, Lordship. Page 426, paragraph 28. Has Lordship got it? In the instant case, promotion had been made by two different DBCs held on 19/2/1998 and 22/1/1998. Both DBCs had made promotions under different roles on different criterion, and the promotion had been made with retrospective effect with the different dates notionally. And the writ petition before the High Court, the promotion of the appellants had not been under challenge. The seniority which is consequential to the promotion could not be challenged without challenging the promotion. Challenging the consequential order without challenging the basic order is not permissible. In this case, Lordship, in the present case, the final seniority list, which is the only imbued order notification in the writ petition, was issued in terms of the recommendation of the DBC, regularization order 76/2024, office notification 5/2024. However, none of those notifications, regularization orders, DBC is under challenge in the writ petition. So without challenging those basic orders, notifications, challenging to the imbued seniority list is not permissible as per this principle laid down by the Supreme Court, Lordship. Next, preliminary objection, page 10, Lordship. B. The petitioners are well aware that their services, along with their private respondents, were regularized by notification dated 7/6/2024, based on the recommendation of DBC, and their seniority has been fixed in order of reference and list of the DBC. The DBC prepared the list of regularized HMAs and fixed their seniority in terms of the notification dated 2/5/2024. However, the notification dated 2/5/2024, which is a vital documents for verbal adjudication of the present case, is not enclosed in the present writ petition. The action of the petitioners amounts to suppression of material facts and approaching this court without plain hand. The writ petition is therefore liable to be dismissed. On that ground, Lordship, I'm relying on three judgments of the Supreme Court, Lordship. Firstly, Lordship, 2010. 14 SEC 3838, Lordship. Paragraph, I'll refer only for paragraphs. Paragraph 20. Paragraph 20, Lordship. Paragraph 21. 22 and 30. I'm reading paragraph 20, Lordship. Strangely, in the list of dates of the special petition, out of which this appeal arises. There is not even a whisper about a large number of cases filed by the appellant. One, challenging the acquisition of land situated at so, the grounds on which the challenge was founded, and the orders passed by the High Court and this court. The appellants who subverts the facts that after dismissal of the first appeal by the division bench of the High Court, possession of the land was taken by the land acquisition collector on so, and transferred to the Delhi Development Authority. What could be possible reason for this omission? Any person of reasonable prudence will at once respond to this question by saying that the sole object of not disclosing the facts relating to the acquisition
Relating to other cases.
relating to other cases was to give the court in dark about the rejection of challenge to the acquisition of portion of land which the appellant are claiming to be waqf property. We have no doubt that the appellants did sue for the purpose of persuading this court to pass an interim order, and they succeeded in this venture because while issuing notice on this court directed there shall be stay of the similar lordship in this case also they obtained the interim order by subversion of material facts, and we are still affected by the interim order because our promotion has been kept on stall despite clearance by the BNR. I'll refer to the necessary documents later on, lordship. Para 21. The principle that a person who does not come to the court with clean hand is not entitled to be heard on merit of his grievance, and in any case such person is not entitled to any relief is applicable not only to those petition filed under Article 32, 226, and 136 of the Constitution, but also to the cases instituted in other courts and judicial forums. The object underlying the principle is that every court has not only entitled, but is duty bound to protect itself from unscrupulous litigants who do not have any respect for truth and who try to violate the stream of justice by resorting to falsehood or by making misstatement or by suppressing facts which have a bearing on adjudication of the issue. Para 13, lordship. Lordship, para 22. Para 22, lordship. It is the duty of a party asking for an injunction to bring under the notice of the court all facts, materials to the determination of his right to that injunction, and it is no excuse for him to say that he was not aware of the importance of any facts which he has omitted to bring forth. Same thing happened, lordship, in this writ petition. Seniority was determined and the government issued a final seniority list, Indian final seniority list in terms of the notification dated 5/2/2024. That notification is not brought on record by the writ petitioner and the present writ petition. And in the reply also, nothing has been mentioned. No reply to this preliminary objection, lordship. No reply at all, lordship. Therefore, they suppress the material facts and obtain the interim order. Therefore, writ petition deserves to dismiss without entering into the merit of the case, lordship. Considering the conduct of the writ petitioners. Now the second decision, lordship, 2008-12 ACC. 2008-12 ACC.
Volume
12 ACC, 2008-12 ACC.
2008.
Yes, lordship, 12 ACC. Page 481. Paragraph 36 and 58.
6
38. May I read, lordship? 2008-12 ACC 481.
481.
KT Sharma, Lordship, party.
KT Sharma versus Steel
Yes,
Authority.
Paragraph 36 and 38, Lordship. A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court would certainly bear in mind the conduct of the party who invokes the jurisdiction of the court. If the applicant makes a false statement or suppresses material facts or attempts to mislead the court may dismiss the action on the ground, on that ground alone, and may refuse to enter into the merit of the case by stating, we will not listen to your application because what you have done, the role has been evolved in the larger public interest to deter unscrupulous litigants from abusing the process of the court by deceiving it. Paragraph 38, Lordship. The above principle have been accepted in our legal system also. As per the civil law, the party who invokes the extraordinary jurisdiction of this court under Article 32 or of a High Court under Article 226 of the Constitution is supposed to be truthful, frank, and open. He must disclose all material facts without any reservation, even if they are against him. He cannot be allowed to play hide and seek or to pick and choose the facts he likes to disclose and to suppress, give back, or not to disclose, cancel other facts. The very basis of writ jurisdiction rests in disclosure of the true and complete correct facts. If material facts are suppressed or distorted, the very functioning of the court and exercise would become impossible. The petitioner must disclose all facts having bearing on the relief sought without any qualification. This is because the court knows the law but not the facts. As I've submitted, Lordship, this preliminary objection is by me in the affidavit. They've filed a reply to my affidavit. Nothing has been replied. That in view of this, in view of that reason, we have not included the notification of 5/2/2024. Therefore, the action amounts to suppression of material facts, Lordship. And the basis of issuing the MBO seniority list is the notification 5/2/24, which has been suppressed. 5/2/25, Lordship, is which has been suppressed by the petitioner, Lordship. Therefore, without entering into merit of the case, Lordship, the writ petition deserves to be dismissed, Lordship. My learned friend, particularly the government also, with a submission of resolution submitted by the writ petitioner against the seniority list has been replied by way of rejecting their grievances. And Lordship, the reason for rejections of the grievances of the writ petitioner is based on the BNR decision and advice. I've enclosed in my affidavit of association. That advice is also not been challenged. Despite the fact that the petitioner is well aware of those decision of the BNR, which I've enclosed in my affidavit of association. My affidavit, page 47.
Yes.
This is already referred to my learned friend, Carmen.
Yes,
Lordship.
yes, yes.
And the reason of reply to the representation of the petitioner is next page, page 48. This is the BNR advice. The repetition of the not to challenge the decision already taken by the BNR. And next page, Lordship. This very important, Lordship. This is the clearance made by the BNR for promotion of 176 assistant headmasters. Because 176 government high schools are running without headmaster, Lordship. In view of the interim order passed by this honorable court, which was obtained by misrepresenting the facts, suppression of material facts, 176 government high schools are running without headmaster in view of the interim order, Lordship. Whether the petitioner names are there in this clearance issued by the BNR, Lordship, kindly look in. The petitioner's names are not there in this clearance given by the BNR department. In other words, Lordship, they are not in the zone for consideration for promotion to the post of headmaster. Now, this is the reason why this petition is fake story for admission hearing. Urgency involved.
How many schools?
176 government high schools are without headmasters. In view of the interim order, Lordship. Despite clearance by the BNR, Lordship, promotion could not be effected because there is an interim order obtained by the persons who are not in the zone for promotion to the post of headmasters. Therefore, my submission is, Lordship, I've raised preliminary objection. Lordship may consider that. And the writ petition claiming seniority over the verbal respondents and the cadre of assistant headmaster is misinterpretation of the rules, because rule doesn't provide that, Lordship. Rule is very clear. The seniority list has been determined and fixed in terms of Rule 25 Clause 2 of the Nagaland Education Service Rule of 2017. Because seniority has been fixed and order of preference and the select list of the DVC. And exactly the rule provides that the industry seniority of promotees should be fixed and order of preference and the select list of the DVC. That is done by the department, so nothing wrong, Lordship. The authority have taken a decision in accordance with Rule 25 Clause 2. And the petitioner is banking on the effective date of regularization given by the DVC. What power has the DVC has to fix the seniority and effective date? Rule 13 doesn't empower the DVC for such action, Lordship. Therefore, Lordship, my humble submission is the writ petitioner failed to make out any case for interference in the new seniority list. And the writ petition is liable to dismiss without entering into the merit of the case because of the fact that I've raised relevant objection with regard to suppression of material facts and challenging of consequential orders without challenging the basic orders. Much obliged.
May I please, Lordship? Lordship here, I'm for respondent number 38 to 155.
The newly implemented.
Yes, the newly implemented, and I don't have 38 to 155. I don't have much to say since I'm only aggrieved by the interim order. Because due to the interim order, our promotion has been kept on hold. Since we were all in the zone for consideration for promotion. And if we see the para 2 of the writ petition filed by the writ petitioner, the writ petitioner aggrieved only with regard to respondent number 3 to 37 with regard to the seniority position. And as for the applicants, respondent number 38 to 155, we are senior to the writ petitioners. And but due to the interim order, our promotion has been kept on hold, and in the entire, as already submitted by my senior counsel, as per Nagaland School Education Service Rule 2017, Schedule 1, there are 177 posts of headmaster. But due to the interim order,
177 or 176?
177 total sanction posts of headmaster. But due to the interim order, there's not even a single headmaster in the entire state of Nagaland in all the schools. And which has greatly affected the smooth operation and overall functioning in all the schools in Nagaland. And as a result, the students' future is also put in peril. And at the same time, school education department has been placed in jeopardy, as there is no officers to look after administration, be it in the district, block, or even in the directorate also. All the submission has been met by my senior counsel. The writ petitioners has obtained the interim order by suppression, misrepresentation, and suppression of facts, because the writ petitioner are challenging the impugned final seniority list dated 14/1/2025. However, before the impugned final seniority list, a tentative seniority list has been circulated, issued, and which was not challenged. So the writ petitioners obtained the interim order by misrepresentation and suppression of facts. As such, the interim order should be vacated and all the interveners, applicants should be considered for promotion to the next higher post for headmaster.
And the IA, that means the IA is for vacation of.
Yes, Lord.
IA number is
67.
any reply?
Just one small and short clarification. I'll not. The argument advanced by one of my counterpart is that DPC has already decided on the issue of seniority. That is wrong. DPC 15/5/2024. After taking all the document, everything into consideration, they have just regularized in the rank of assistant headmaster with giving the definite date of regulation, that much. No seniority was set on, they don't have the power to do that also. DPC simply held its meeting and after due consideration has regularized the officers, assistant headmasters with effective date of regulation. So based on that effective date of regulation, the formal regulation order was issued by the government showing the date of effective date of regulation, that much only. So seniority has to be decided by the department. So therefore, that is a wrong argument. So that's just to satisfy on that. And then, as I have pointed out, the Supreme Court is very clear that the seniority the seniority among the members of the same grade has to be counted from the date of initial entry into that grade only. That is only my point. In the grade of assistant headmaster, since the effective date of regulation is I'm above them. So therefore, going by that, seniority has to be published based on that. That is my argument, and the prayer also same. Even the prayer is that to quash and set aside the impugned final seniority list, and then direct the state government to publish the seniority list in terms of the rules, that much. So argument that the DPC has finalized or prepared the seniority list, that is a wrong submission, that much.
This, no, you just tell them to get photocopies. I don't want to carry the book. Still no. Internet counsel for the petitioner, Mr. Azo, Mr. Lima Wapang for the respondents numbers. Mr. You get the numbers later, okay? And Mr. Wati Jamir for the respondents such and such. And also Mr. Your Nangami for the said respondents, also heard Mr. Hisinlo Sim for the applicants in IA 67 of 2025. Appearing already served.
My lord, item 11. My lord, item 11, my lord, may I pray that it may be taken up on some other date, my lord? Item 11.
You want?
My lord, with the 27th, my lord.
Under prayer. List the
27th,
27th
24th July, my lord, item 11.
July.
24th, my lord. I'm sorry, 24th.
July or June? You want in July or June?
July, my lord, July.
24th July. Item
July,
11.
my lord, July. Item 11.
11,
Okay,
yes.
item 11 for hearing.
I'm for the petition.
Okay.
For bail hearing, item number 1.
Yes. Petitioner, who's for the petitioner?
Bail hearing, Itanagar.
This one. Lower court records. They are unable to print out much. Yes. Can you hear? I think their audio is not working.
Your Lordship, please.
Yes, please submit.
Your Lordship, this is a bail application, Your Lordship. The
Yes.
accused is in the judicial custody for more than 1 year, 2 months.
Hmm.
Your Lordship, in the case, Your Lordship, charge sheet has been filed. CC has been taken up and the accused person has been framed under section 21B of NDPS Act. Your Lordship, from the charge sheet, Your Lordship, from the record available, nothing new incriminating material is emerging, which necessitate the further detention of the arrest of the accused person. Your Lordship, may please come to page number 8 of my petition.
1 minute. Why has this come before this court? Is there an earlier order? Is there an
Yes, Your Lordship, before earlier this matter was taken up in this honorable court, whereby, Your Lordship, it was whereby by order.
Just take us to that order page.
Page number 17, Your Lordship.
Page 17. Okay, so you approach the session judge UPIA? Did you?
Yes, Your Lordship.
And it was rejected.
The application was filed before the session court.
Okay.
The order was not passed even after the lapse of 2 months. So therefore, Your Lordship, I approached the Honorable High Court, whereby Your Lordship, Honorable High Court, by order dated 8/4/2025, has directed the session court to pass necessary order.
Yes.
So Your Lordship, accordingly, session court has passed the order rejecting the bail application. So Your Lordship, this is the subsequent bail application. Your
So
Lordship,
where is
I'm
that?
coming up with the bail application.
No, where is that rejection order? Page.
Page number 15, Your Lordship.
15.
15.
No, 15 is a continuation of the High Court order.
Is the order passed by
Order
the
dated 12 to
UPI.
25. 12 to 25.
12 to 25.
12 to 25.
And Your Lordship may come to the arrest memo.
Yes. No, wait, we have to see the first bail disposal order. Anyway, where's the PP?
Your Lordship, PP is not appearing, Your Lordship.
Have you served notice?
Yes, notice has been served to the PP.
Then we'll fix another
On the
day.
request of the PP, this matter has been brought up before this learned court, Your Lordship.
We'll fix another day. And the records also, the full records have not reached. Oh, it is gone. That's the remaining. Complete. We'll fix another day, okay? Heard learned counsel for the petitioner,
Yes,
date such and such.
Your Lordship, kindly tomorrow maybe 6.
Tomorrow is, yes, tomorrow we have division bench here. So maybe Thursday.
Thursday.
Learned
Okay,
counsel
Your
for petitioner. Your name?
M. Kamchan.
Just check out from the record. When the matter is called, the learned PP is not present. Accordingly, list the matter on Thursday will be 19th. List the matter on 19th. And the lower court records, copies of the scanned copy of the lower court records have been received. It's lists on Thursday, 19th. Okay, 19, you informed the PP?
Yes, Your Lordship. Oblige, Your Lordship.
Thursday.
For motion from the supplementary cost list, item number 16.
May I please, my lord? My lord, this is a criminal division petition, my lord, against the dismissal of the appeal, Your Honor, before the session judge, Mokok Chumon. Now, here in this case, my lord may find page number 64. This is the judgment of the CGM court, Mokok Chung, wherein the learned CGM has convicted the appellant petitioner for the offences 498A, 354 and 506 IPC for a period of 1 year, Your Honor. Thereafter, he referred an appeal before the district and session judge, and accordingly, his appeal was dismissed by upholding the conviction of this, Your Honor, petitioner. Now, we are before this honorable court for the interfering with the order of this judgment of the conviction, my lord. Now, here in this case, the my lord may find, Your Honor, as per the FIR and as per the deposition and 161 statement which was recorded by the police officials, there is no offense of 498 made out, Your Honor. As well as there was no offense made out under section 354 of the IPC, Your Honor. I would like to highlight the deposition of this lady, which was recorded before the IO, page number 30. Page number 30. There is allegation of simple allegation of domestic violence against the petitioner. Page number 30. Page number 30. That was initially recorded by the IO of this case on 10/9/2021. As per this statement, they were ready for the mutual settlement of their issues. So far, the connection of this statement, and thereafter, again, his statement was recorded. Her statement was recorded on page number 31, my lord, by the IO. Page number 31, and from the apparent reading of this statement, my lord may find there is no offense of 498A, 354 or 506 made out against the petitioner.
Okay, we'll issue notice. Who are the respondents? Who is this to the complainant?
Complainant and the state of Nagaland, my lord.
Who's accepting notice?
My lord, one IA has been filed in this regard, my lord, for the suspension of sentence and allowing the petitioner for remain on previous bail.
Issue notice in that also. Heard learned counsel for the appellant, such and such. This is an application. This is an appeal. Oh, this is civil revision.
Criminal division petition.
438, okay, this is a criminal revision petition under section 438/440 of the BNSS against the impugned judgment and order dated 25/4/2025, passed in criminal appeal 1 of 2024 by the learned district and session judge Mokchung, Nagaland, upholding the conviction of the petitioner under section 498A/354/506 IPC. So the learned PP, she, V. Momi accepts notice on behalf of the state respondents. And the petitioner shall take steps for notice on the respondent number 2 by registered post with AD, as well as usual process. The notice is made returnable in 4 weeks. So, and the IA. This application under section 397 of the CRPC has been filed, praying for suspension of the. You have not put the equivalent section of BNSS.
Actually, this is an old case, my lord. That's why BNSS section has been not put in this.
Okay, application under section 397(1) of the CRPC, praying for suspension of the sentence passed by the learned principal district and session judge Mokchung by judgment and order dated 25/4/2025 in criminal appeal 1 of 2024, and the judgment and order dated 9/4/2024 passed by the learned CGM Mokchung in GR case 105/2021. Issue notice to the respondent number 2, returnable within 4 weeks. Learned PPV Zimomi accepts notice on behalf of the respondent number 1. The petitioner shall take steps for notice through registered AD with AD and as well as usual process. List of the 4 weeks.
My lord, at
We'll
least
consider-
suspension of sentence may be considered.
We'll consider the next day.
For hearing, item number 5.
Is there another matter after this? I think we will, I think we will list that another day. Who's there for? Are the parties here? Item, which item?
More Chamir and what the Chamir, I think, 2 Chamirs
Two Chamirs.
are waiting it.
I think.
They are
we won't be-
outside.
I think we won't be able to take it.
They will inform Lord.
Yes. Because there is only so much the brain can also take.
When Lordship is fixing that other matter, what the Chamir junior is here.
Maybe next week, next
Okay.
week. List the matter next week, the other hearing matter. no? Just said due to paucity of time, the matter could be taken up this next week.
There, please, Lord.
Yes.
My Lord, this is an application against the order dated to the 6/9/2023 passed by the learned civil judge Seniority Division Kohima, whereby an application for amendment of the plaint has been allowed at the effect end of the proceeding, in spite of vehement objection from the defendant's lordships. Brief background before coming to the facts of the case, before coming to the impugned order. In 1970,
1 minute, okay.
this is just a little background about the case. Otherwise, there is a checkered history of litigation about this land. Sometime in 1969, the process for land acquisition has been started, but in 1970, about 78.76 acres of land has been acquired by the government of Nagaland in Aratura, which is presently known as the NST colony. So in short, the present NST colony is the land which has been acquired from the 8 land owners from 2 villages. That is a Kohima village and the other is Kudama village. Sisama village. So from 2 villages, from 8 land owners, this entire land has been acquired. The area of land is about 78.76 acres of land. So what happened, as is normally happen in Nagaland in many cases, since the government land is so big, massive land, a colony has already been acquired. It so happened that some land has been apparently allowed by the government illegally, some officers in 1980s. So hearing that, the original landowners, that is from Kohima village, they have also lodged a complaint to the government saying that, look, we have sacrificed our land for the development of the government, for government department development. Therefore, allotting the land to the private individuals is not proper and illegal. So you are requested to clarify all these things. And in 1980s, one Vilali Silitzer and few others, they started encroaching the land also. Government officers have started allotting unauthorized allotment, issuing unauthorized allotment. At the same time, some encroachments are also there. So complaint was lodged and the deputy commissioner has directed for a spot verification. EAC, Extra Assistant Commissioner, has conducted the spot verification, verified and found that those people were the encroachers. The land has been, NST land has been encroached. So eviction notice was issued. That was challenged.
The encroachers.
Yes, to the encroachers. That was challenged by way of a writ petition. And the writ petition was disposed of with the direction to file an appeal before the commissioner, Nagaland, because under the provisions,
Appellate authority.
appellate authority is there. So that was done. Appellate authority has dismissed their appeal. Meantime, what happened in 2007, a civil suit was filed by the present plaintiff, of course, his father. And an ex-party order was passed, declaring the land in favor of the plaintiff. That was an ex-party. That was challenged. Subsequently, that was modified. But then there were so many litigations thereafter. And then against, and let me come to that civil suit, page 110, civil suit 2 of 2017. A suit was filed. Page 110.
Yes, 110.
And Lordship, we kindly come to paragraph 15, that is page 117. Paragraph 15. Let me read this paragraph. That the cause of action and the right to sue arose against the defendant when the defendant number 3 issued the eviction order dated 12/6/2014. So the acquisition of the garment in 1970 has never been challenged by the plaintiff. But before this, can we come to page 89?
89.
89. This is the eviction order 12th June 2014. So this order has been challenged. And then after a series of litigation, the appellate authority order lordship will find at page 98. This is the appellate authority order. That is the Commissioner Nagaland. This order was challenged in WPC number 30K of 2016. This order dated
3rd February.
This is
3rd February 2016.
yes. This 3rd February 2016. This has been challenged in WPC number 30K of 2016. And that was disposed of by this honorable court on 24/4/2017, granting liberty to the petitioner to approach the civil court.
Okay.
And
Then
this order has been challenged in the High Court by filing WPC number 30K of 2016, page 102. By order dated 24/4/2017, the writ petition was disposed of, granting liberty to the petitioner to approach the civil court. And then an order was passed by the Honorable High Court not to disturb the possession of the petitioner. On the strength of that,
for 45 days.
yes, they are under possession of the land on the strength of the High Court order. And in the order of this Honorable Court, I would like to refer to two paragraphs. One paragraph, Lordship, page 108.
Yes.
Mr. Lordship, got it?
Yes.
Paragraph 7. After having considered the pleas taken by the parties, this court is of the considered opinion that to decide the issues in the case, both questions of fact and law are involved. Therefore, writ court is not the right forum for adjudication of the same. It is clear from the copy of the judgment on which the petitioner based his claim of title and ownership. Lordship may mark this title and ownership. In the earlier proceeding, when they filed the suit initially, they have claimed title and ownership. They were very much aware that filing of the civil suit is claiming title and ownership. And the problem is here in the present impugned order, they have prayed for possession of the land, not title and ownership. They have not claimed title and ownership. And in the application, they have mentioned that inadvertently, they have not prayed claiming title and ownership. But even the High Court, when this order was passed, this Honorable Court on 24/4/2017 has clearly mentioned that the claim over the land is claiming title and ownership over the land. So, claim of title and ownership over the land issue that is that it was passed by the Chief Judicial Magistrate Kohima, who has no civil jurisdiction, because we have raised the point that how come a civil judicial magistrate can pass a civil proceeding. That is what we have raised. But at the same time, one cannot just brush aside the claim of the petitioner that the suit was filed before a proper civil suit having jurisdiction over the matter. Two, the judgment and decree were passed under the name of Chief Judicial Magistrate. Further, prima facie, it is clear that the land occupied by Nagaland State Transport, where the land in question is situated, was acquired by the state government from different landowners after conducting survey, and compensation was paid to them. But the landowner from whom the petitioner claims he has purchased the land in question was not among them. All this and more facts which are relevant for deciding the dispute over the land in issue, that is all that may also be marked, because the dispute over the land was title and ownership. And the plaintiff was aware about this issue. Petitioner will have to be proven with evidence for which the civil court is right forum. Therefore, without much ado, the writ petition is disposed as follows: that the petitioner may approach the civil court having jurisdiction for the remedies sought for in this writ petition. And to do this, he is given 45 days from today. Till then, the respondents are directed not to disturb in possession. On the strength of this order, they are in possession till date. Liberty was given to approach the civil court. After this, the civil suit 2 of 2017 has been filed. And the High Court said to decide all the issues by the civil court on the dispute. And the dispute in the High Court was claiming title and ownership over the land. And the title and ownership not claimed in the civil suit. That is why we are saying that the petitioner, the plaintiff, was not diligent while filing the civil suit. That was our plea. And then the Lordship will find the civil suit, which I have referred to in page 110. And the brayer in the suit is at page 118. Page 118. Has your Lordship got it?
Yes, page 1.
Yes, here, paragraph 20. The plaintiff therefore prays for a permanent injunction against the defendants' authorities not to interfere the peaceful occupation and possession of the plaintiff land and house. And the others are not relevant for us. So here, the petitioner, the plaintiff has not prayed for title and ownership over the land. They have only prayed for peaceful occupation and possession. Here, Lordship, my submission is occupation may be in any form. Occupation and possession may be in any form. Under many situations, one can occupy and possess also. But the title and ownership can be through a legal means. By encroaching somebody's land, I may occupy some land also, I may possess. But I must show that from where I got that title to occupy and to enjoy the land. In 2017, about 10 years before filing the suit, because the suit was filed in 2017. In 2007, when a suit was filed, there in that proceeding also they have claimed title and ownership over the land. That is why I was mentioning that kindly note this. What was their claim in the initial proceeding, earlier proceeding, and what they have filed in the present suit. 10 years back, they were claiming title and ownership. But when in 2017 the suit was filed, it was filed claiming possession and occupation. So, pursuant to this, the NST department has filed written statement of defense and examination in chief. The plaintiff was examined and cross-examined also. Trial has already been commenced. Here, one submission.
Trial
Lordship,
is
here.
going on.
Yes,
Oh.
but earlier, the earlier concept was, Lordship is well aware, before amendment of the CBC, it can be at any stage. Amendment can be allowed. But after the amendment of the CBC, proviso has been inserted that after commencement of the trial, no. Amendment should not be allowed. And court should be very, very cautious for allowing the amendment. And plaintiff has already cross-examined,
Because
was already,
the question usually arises, when does the trial start?
Yes.
At what stage?
yes. When the trial commences, when evidence is led, trial is already commenced. And the date for examination of the PWs has been already fixed.
DW.
Yes,
That means for PW, the respondent here has already been examined and cross-examined.
yes. Now, now kindly come to again page 128, annexure 37. This is the interlocutory application filed under Order 6, Rules 17, CPC, where they have sought for amendment of the plaint. And the reasons for the amendment has been mentioned in paragraph 2 of the application, which Lordship will find at page 129. Paragraph 2. Mr. Lordship, got it? Near it, paragraph 2. That in filing the said civil suit, the plaintiff had, despite due diligence, inadvertently failed to pray for a decree for declaration of title in his favor. So this is the reason. Inadvertently failed. Despite due diligence, they have mentioned that. But what I'm submitting is due diligence they have not exercised, because in 2007, when they filed the civil suit 2 of 2007, there they have claimed for title and ownership over the land, and the disputed land is the same, not a new place. And this honorable court, when order was passed, this honorable court has also clearly mentioned that the title over the land, High Court order, Lordship will find, yes, at page 108, I have already referred to in paragraph 7. This honorable court has also said that the dispute, the claim of the petitioner is the title and ownership over the land. Page 108, paragraph 7,
That one which
second
was
para,
sort of-
sub-para, second line.
Same time, one second.
And if at all this is not correct, they could have sought for review of the order of this honorable court, or they could have challenged, which they have not opted for. No appeal, no review of this observation also, which clearly says that in the civil suit, the petitioner has claimed for title and ownership over the land.
The earlier civil suit was number
Earlier civil suit was CS2 of 2000. Just a minute.
was
Shoot.
the present one is 2 of 2017.
That is the
So
second
I
one.
think earlier one is 2 of 2007.
CS2 of 2007. CS2 of 2007.
In that title, and ownership was
Claim.
free.
Only the order is available. Application is not there. Lordship will find the order at page 74. This was passed on 25/8/2008 by the CGM. Incidentally, order is ex parte judgment is 14/7/2008. And here, Lordship will find in the first three sentence and up to fourth line, I will read 174.
Page
74. This is the ex parte order passed by the Chief Judicial Magistrate. Page 74, has your Lordship got it?
Yes.
The civil suit arose for claim of titleship. Here also it is clearly mentioned in the order. Over a plot of land at the present NST colony Pesama, Kohima, which was earlier allegedly claimed as ancestrally called Megatri. The plaintiff claimed that the land had a boundary of so-and-so, and that he is the legal and lawful owner of the land. Next page, the first line. So the claim in the earlier suit was also about title and ownership over the land. So I believe I have met the position clear, Lordship, with regard to the claim of the petitioner, plaintiff, which he was claiming earlier before filing the present suit in 2017, where he has claimed for occupation and possession over the land. And by filing the IA under Order 6/17, he has mentioned that after exercising due diligence, due to inadvertence, the claim for title and ownership has not been claimed. That is the claim of the plaintiff. And we have filed WEs, a detailed WEs was filed against this application. And then the matter was heard. Very interestingly, after hearing the case, the small application, which was for amendment of the application, plaint. After hearing the case, after 2 years, 5 months, this order, impugned order has been passed. See how
after 2 years.
the parties have submitted what was submitted. Maybe he may have some magical power to remember all this, whatever the parties have submitted. In the trial court, there is no recording of like we have today. So after conclusion of the hearing, 2 years, 5 months was taken to pass this order.
Where is the impugned order?
And
Let's see.
this order was not passed in the open court in a surreptitious manner without publishing the cost list about the pronouncement of the judgment. It was passed. We came to know after some delay only about the passing of this order because it was not published in the cost list. No prior information was given. Impugned order is at page 137. It is dated 26/9/2003. It was heard on 27/4/2021, and judgment and order was passed on 26/9/2023. after 2 years, 5 months.
Heard on?
It was heard on 27/4/2021. And judgment order was passed on 26/9/2023. So it took about 2 years, 5 months. And since it is a short order, I may be allowed to read since this is the ambient order. But to save time, Lordship, I may start from the relevant portion, page 138.
Operative portion. 38.
From page 138.
Yes.
Has Your Lordship got it?
Yes.
I'm reading from the third paragraph, the learned counsel R. Iralo. Learned counsel R. Iralo, senior advocate for the applicant, submits that by incorporating the additional relief sought, the nature of the suit ought not be changed, as the ultimate relief will only be determined by the court at the end of the trial, after reducing all the necessary evidence. To support this submission, learned senior counsel relies on the decision of the apex court, and then the judgment is quoted. It is as such submitted that changing the nature of relief does not amount to changing the nature of the suit. Learned senior counsel further submits that the proposed amendment would not cause any prejudice or injustice to the defendant, but instead it would minimize litigation. He relies on the decision of so-and-so. Opposing the application filed by the applicant, Mr. C.T. Jamir, senior advocate, appearing for the defendant number 1 and 2, submits that the application for amendment lacks due diligence, as trial in the civil suit has already commenced. In this regard, learned senior counsel relies on the judgment of G. Samuel and others versus Gutumesh, so-and-so, judgments are there. He further submits that the nature of the suit will be changed, as the proposed relief and the existing relief in the suit are different to one another. As such, he submits that if the amendment is allowed, prejudice would be caused to the defendant number 1 and 2. The defendant number 3, DC Kohima, has also filed an objection stating that the application ought to be dismissed as the suit is at stage of trial, and if the same is allowed, it would only slow down the trial. I have heard the submission of all the parties. Order 6, Rule 7, CPC provides as follows. 17. The court may, at any stage of the proceedings, allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of the due diligence, the party could not have raised the matter before the commencement of trial. In the instant case, 14 issues were framed on 16/11/2018, and the plaintiff subsequently was cross-examined on 28/11/2019. Thereafter, when the PW2 was awaiting to be cross-examined, the instant application was filed by the plaintiff. In the instant application, the applicant seeks to amend his plaint by incorporating an additional relief as stated above, and as well as amend paragraph 18 of the plaint consequently. I am of the opinion that if the application is allowed by adding the relief sought for, the nature of the suit ought not be changed, despite submissions made by the opposite parties 1 and 2 that prejudice and injustice would be caused if they have not demonstrated how or in what manner prejudice ought be caused to them. In addition, this court also finds that the application was moved after the plaintiff was cross-examined. The other plaintiff witnesses are yet to be examined, including the defendant witnesses. As such, even though trial has begun, this court does not find that there is lack of due diligence, negligence on the part of the applicant in filing the said application. The apex court in so judgment has been shown. And then next page 141. Second last paragraph. Therefore, Therefore, this court is of the view that no prejudice would be caused to the opposite parties, and as such, and as the basic structure of the suit would not be altered by the proposed amendment, this application is accordingly allowed. So that's how the learned trial court has passed the order, and we are agreed by this order. Now, the suit has been filed by an illegal encroacher claiming permanent injunction and not to interfere with the peaceful occupation and possession. So, as I have shown to your lordship, the suit was filed for possession and occupation. As I was mentioning earlier also, possession and occupation may be of any form. I am occupying the house on tenancy basis also. I may be possessing, I may be occupying, but on the basis of what? That has to be ascertained. And they have not claimed for title and ownership while filing the plaint. Possession and occupation and declaration, title and ownership are two different things. Ownership and title means absolute owner. He has every right, and title will be on the basis of some valid document. No doubt he was in possession, he was in occupation. The Honorable High Court order is also there. Basing on that, on the basis of that, he should not be evicted, because we have already issued eviction order, but by taking this and that excuses, somehow they are able to manage. And then while granting liberty by this Honorable Court to approach the civil court, they were allowed to occupy, and they should not be evicted. So they were in possession and occupation of that particular plot of land. But they are not the owner and not the title holder and owner. Whereas in the earlier proceeding, they have claimed title and ownership over the land. Therefore, we objected vehemently that, look, this will definitely change the nature and character of the case. You were not an owner, you were not the title holder, and now, by allowing the amendment, if that is allowed, then they will claim title and ownership. So the logical conclusion is, at the time of filing the suit, the plaintiff was not aware whether he was the land owner or the title holder. That is the reason why he has filed the suit without claiming title and ownership over the land. So the owner himself, the plaintiff himself, was not sure whether he was the title holder or the owner of the land. Therefore, if the amendment application is allowed, it will definitely change the nature and character of the suit. And see the reasoning. They have not demonstrated how or in what manner prejudice would be caused to them, that is to the defendants. And then in the concluding part, no prejudice would be caused to the opposite party, as the basic structure of the suit would not be altered by the proposed amendment. So in what manner it will be prejudiced has not been shown to the court. That is the reasoning of the court. Now, apparently, court have not understood. If the title of my title is gone to the encroacher, I will not sustain any loss. That is what it appears. Because the finding and reasoning given by the Honorable Court below is no prejudice will be caused. The fight and the battle is only about the title of the land, the ownership. And if that is taken away, in no way we will be prejudiced. That is what the reasoning is. So, by allowing the amendment, if the title is given to somebody else, definitely we will be prejudiced. Therefore, the reasoning arrived by the learned court below has no backing of law and no reason to support, and no logic also. As I was submitting before also, as if the plaintiff do not know whether he is the owner or not. That is why he has not claimed the title and ownership over the land at the time of filing the suit. And the court did not know and distinguish the possession, occupation, and the title and ownership. There is a vast difference. As I was mentioning, possession and occupation may be in any form. Even an encroacher may be an occupation and possession. But the moment he is found that he is an encroacher, he will be evicted from the land because he do not have the valid title. And can we come to page 122? In the examination, in the deposition, also, they have filed an affidavit.
122. Hmm.
122 is the affidavit filed by, this is an examination in chief. And kindly come to page 124, relevant portion. Right. Till today, the second paragraph, page 124.
Yes.
That's your lordship, got it? Yes. Till today, the suit land and the adjoining areas remains a private individual land. However, since the defendant authorities are illegally interfering with my possession and occupation. See, I pray that a permanent injunction against the defendant authorities not to interfere and peaceful occupation and possession over the suit land. See, in the examination in chief, this is his statement, the plaintiff's statement.
Permanent injunction.
Yes. That is about the not to interfere, peaceful occupation and possession. That is already stated. He has given the statement already. And now, and on the basis of this, we have cross-examined. And now he is coming with a plea that no, due to inadvertence, I have not mentioned about claiming title and ownership over the land. So that will definitely change the nature and character of the suit. And that too, after the commencement of the trial, after he is examined and cross-examined, the order has been passed. The amendment application has been allowed. Therefore, the plaintiff was not diligent in view of the reasons what I have already stated. And the application ought to have been dismissed instead of allowed. So I would like to cite one or two citations in support of my submissions. On the diligence, 2024 3 ACC 705 on order 6 rule 7. relevant paragraphs, Lordship. Paragraph 10, 12, 14, 15, 16, and 18. I will not read. Let me not read. Those are the relevant paragraphs.
This is on.
On Order 6, Rule 7, and no diligence. When there is no diligence, then application is liable to be dismissed. On principles of Order 6, Rule 17, 2009, then SCC 84, paragraphs 63, 64, and 65. Paragraphs are short, but let me not read. Those are the relevant paragraphs where how an application under Order 6, Rule 17 is to be examined and decide, Lordships. Those are the important principles. These are very important judgments. So taking into consideration of all these judgments, Lordship may decide the case, Lordship. Much obliged. I conclude with that.
Yes.
Please, Your Lordship. Your Lordship, I was under the impression that I need not go into the past facts of the case, but I need to make certain clarifications in respect to the civil suit number 2 of 2007. Now, this suit was filed by one Sri Vilale Seletsu. He expired already after returning from his underground activities. He returned to the village and then he filed this suit. And this suit was after issuing proper notice to the government. The suit was decreed ex parte. And so I'm not Vilale, the present respondent herein, and who filed the suit in 2017 as directed by the Honorable High Court, is not this one. Now, the present respondent, whose name is Yusakoto, this present respondent, after the trial court in civil suit number 2 of 2007 passed ex parte decree in favor of late Vilale Seletsu as the owner of the disputed land. I purchased a small plot around 6,400 square feet. And I constructed my house. I leveled the ground. Then subsequently, the Revenue Department issued notice, which is the outcome of all these now present litigations. In 2007, though ex parte decree was passed.
But it's the same land.
It is only a portion of it. Because the late Vilale,
You
he
bought it
owns,
from him.
Your Lordship.
You bought the land from this Vilale.
Your Lordship. And it's only a small portion of land, not the whole land. And the other portions of land, now it is under the occupations of several individuals. Several individuals. As far as the acquired land, so-called acquired land, as mentioned by my learned friend, now those lands As per records, compensation was paid to the son, to the father, who was the NST manager at that point of time. Therefore, somehow compensation was paid to a non-land owner. So when I returned, I found that they are trying to occupy my land. So I issued notice, then I filed the suit. Not I, the then late Villalya Seletu, and decree was passed in his favor. So after that, I purchased 6,400 square feet of land from late Villalya Seletu. That is one clarification. Now, the application under Order 6, Rule 17 was filed in 2019. The suit was filed in 2017. Then this application was filed in 2019. Now it was filed then after hearing, I'm not very sure whether it was heard before the COVID period. But I think it was heard after, because 2019, then 2020, 21, court could not function, as everybody knows. Therefore, there was some time. And as stated by my learned friend, the application under Order 6, Rule 17 was filed after about 2 years, 4 or 5 months of filing the suit. Then, since the matter has been, this misapplication for praying for amendment has been kept pending for some time. Although right now we do not have the copy, but we approached the High Court. And then the High Court directed the trial court to dispose of the matter. And so the matter was disposed of in 23 September. That's how the matter has been delayed, but we pursued, and finally, as per the direction of the High Court, the matter was disposed. Now, all nitty-gritty details, since the court is not going to give its finding on those things, except those clarifications, I will not go into the other details. Now, firstly, as far as this petition is concerned, this was filed under section Article 226, 227 of the Constitution. Therefore, this is a revision petition.
Yes, revision.
This is not an appeal. An application under 227 cannot be treated as an appeal. Although the High Court under 227 has plenary jurisdiction, but it is not an appeal. Then under 227, the court has to go regarding how the trial court has dealt with the matter. Now, my learned friend alleged that the petitioner alleged that under Order 6, Rule 17, his submission was as if the trial court has been totally barred or absolutely barred from allowing an amendment application. That is not correct. It is limited. Now, the trial court has no absolute authority to amend an application. But in the present circumstances, once the trial starts, it says in the proviso of Rule 17, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of the trial. So there is no absolute bar. And as we see the application, petition, the revision petition, the only grievance is that prejudice should be caused to the respondent, applicant. And
So the court has to look into that due diligence.
yes. Now, the trial court, because initially, now in 2007, as submitted, after the suit was filed by Villale, in 2008, ex parte decree was passed in his favor, declaring the ownership and title of the land to late Villale. I purchased from him. Therefore, at that point of time, when the suit was filed, as far as I'm concerned, title is already there. Title in favor of the deceased plaintiff, Villale, is already there. So my title is there already, because that has not been challenged at any point by any party. Therefore, that impression has subsequently crossed the plaintiff's mind, present respondent. And therefore, for the sake of to be on as an abundant caution, although the plaintiff may, the plaint may proceed even without that, but as an abundant caution. Now, although title has already been declared in favor of the owner of the purchased land, now the plaintiff needs to amend this petition, his plaint. And because of the circumstances, the application has been filed after omitting an inadvertence, because that is an inadvertence. Now the prayer of the plaintiff in the plaint, it is not for occupation or for possession. The prayer is for to refrain to issue an injunction order against the respondent's authority not to disturb the possession and occupation of the land by the plaintiff. I'm not praying for occupation, or I'm not praying for possession. Since I've already been in possession after the purchase, my specific prayer is for not to disturb my possession and my occupation, my peaceful possession and peaceful occupation. That was the prayer. I'm not praying for my possession, or I'm not praying for occupation. That my little friend has made a mistake there. Now, in the pleadings, it is seen that all from the impugned order, we see that the no illegality has been committed by the trial court by allowing the application. Now, by allowing the application, on the contrary, the real issue in the dispute would be finally settled. And if that is so, then no prejudice would be caused, or no injustice would be caused to the respondent defendants. The purpose of allowing an amendment application is, and the duty of the court in such case is that whether this amendment would assist the court to decide the real issues in question. Otherwise, and one reason is to avoid multiplicity of suits. To avoid multiplicity of suits. I can file a suit I can file another suit for declaration of title. But without doing that, I'm filing the application for amendment, so that the court
can club this together and then decide the real issue in question. That is the most important factor for amendment of applications. Whether by allowing such application, the dispute, the real question, the real issue in question of the dispute would be settled. Therefore, the trial court has allowed the application and no prejudice, because the court sees that no prejudice would be caused to the defendants. Now, the plaintiff has filed the list of witnesses and the depositions already. And the plaintiff has been cross-examined by the defendant already. Only the plaintiff. After that, the plaintiff filed this amendment application. Now, no prejudice or injustice would be caused to the defendant for the reason that because of the amendment, if the defendants wants to further cross-examine the plaintiff after the amendment, the court can further summon the plaintiff for further cross-examination by the defendant. I'm not praying for the amendment of his depositions or amendment of his witnesses already submitted. Therefore, no injustice or prejudice would be caused to the defendant, because the defendant still has got all the liberty to further cross-examine and to cross-examine the plaintiff as well as all his witnesses. Now, one factor is that the application for the amendment, we have not said anything to change even a single sentence of the plain statements of the plaintiff. We prayed only for the addition in the prayer clause, and since we are seeking for a declaration of title, now in such cases, we need to submit ad valorem court fee. That was the only two prayer made before. No alteration, addition, subtraction of the statements already made. No prayer for the change of the depositions already given before the court, or to submit additional affidavit deposition of the plaintiff. Therefore, it does not change the character of the suit. The character of the suit may be changed when you made some alterations in your statement in the plaint, not in the prayer. The addition of prayer in the prayer clause will not change the character. The character will be changed when you made alterations, additions, subtractions in the statements in the plaint. Here it is not the case. And as I've already submitted, the plaintiff has already been cross-examined by the defendant. And because of this amendment, allowing the amendment, if he further wants to further cross-examine the defendant, the court will certainly grant. He will not be obstructed or he will not be denied of that liberty. The court has the liberty to do that. And then the rest of the depositions of the witnesses it remains as it is. Therefore, in cross-examining those witnesses, the defendant can bring any question, including all this, the question of the prayer made in this amendment upon the witnesses of the defendants. And therefore, since there is no change of the character of the suit, and since by allowing the application for amendment, the real question in controversy can be decided and finalized, the trial court has rightly, by exercising his limited power of amendment, allowed the application. Now, the trial court has also reflected certain rulings submitted by the application, by the applicant. I'm sorry, by the applicant means the plaintiff. And in this respect, this will be only a repetition, but I'd like to place before the court the relevant copies. One is 2002 7 SEC 559 in the case of Sampat Kumar versus Aya Kanu and another. 5, 7, and 8, paragraph 5, 8, 7. Paragraph 5, 7, 8, and 9. May I read the lordship? The short question arising for decision is whether it is permissible to convert through amendment a suit merely for permanent prohibitory injunction into a suit for declaration of title and recovery of possession. 7. In our opinion, the basic structure of the suit is not altered by the proposed amendment. What is sought to be changed in the nature of relief sought for by the plaintiff? In the opinion of the trial court, it was open to the plaintiff to file a fresh suit, and that is one of the reasons which has prevailed with the trial court and with the High Court in refusing to the prayer for amendment and also in dismissing the plaintiff's revision. We fail to understand if it is permissible for the plaintiff to file an independent suit, why the same relief which could be prayed for in a new suit cannot be permitted to be incorporated in the pending suit. In the facts and circumstances of the present case, allowing the amendment would curtail multiplicity of legal proceedings. 8. In so and so, this court has taken the view that where a suit was filed without seeking an appropriate relief, it is well settled rule of practice not to dismiss the suit automatically, but to allow the plaintiff to make necessary amendment if he seeks to do so. 9. Order 6, Rule 17 confers jurisdiction on the court to allow either party to alter or amend his pleadings at any stage of the proceedings and on such terms as may be just. Such amendments are directed towards putting forth and seeking determination of the real questions in controversy between the parties shall be permitted to be made. The question of delay in moving an application for amendment should be decided not by calculating the period from the date of institution of the suit alone, but by reference to the stage to which the hearing in the suit has proceeded. Pre-trial amendments are allowed more liberally than those which are sought to be made after commencement of the trial or after conclusion thereof. So, Your Lordship, may I just stop here once? Even after conclusion, amendment can be made until the judgment is passed. In the former case, generally, it can be assumed that the defendant is not prejudiced because he will he will have full opportunity of meeting the case of the plaintiff as amended. In the latter case, the question of prejudice to the opposite party may arise, and that shall have to be answered by reference to the facts and circumstances of each individual case. No straight jacket formula can be laid down. The fact remains that a mere delay cannot be a ground for refusing a prayer for amendment. Then the other one is 2018 SCC, volume 6, from page 5, 6, 7, paragraph 4, 5, and 6. Paragraph 4. The High Court, however, dismissed the said revision petition by its judgment and order dated so, which is presently under appeal. It was observed by the High Court so in paragraph 11, no doubt the amendment would not change the nature of the suit. However, all amendments which do not change the suit cannot be allowed, particularly after the commencement of the trial. It has been found by the court that necessary pleadings are already in existence in the original plaint. 5. In the present case, the record of civil suit number so, in which ex parte decree was passed on 1969 is not traceable in the circumstances. There would be possibly some inability to obtain correct particulars well in time of the part of the appellant at the time when the application for amendment was preferred. Only 2 official witnesses were examined. The nature of the amendment are as proposed, neither change the character and nature of the suit, nor does it introduce any fresh ground. The High Court itself was conscious that the amendment would not change the nature of the suit. In the given circumstances, in our view, the amendment ought to have been allowed. In any case, it could not have posed any prejudice to the defendants. Then skip the other paragraph. Then another one you mentioned. Then now in this 2002 SCC volume 1, this is in regard to application file under section 227. In what circumstances the High Court may consider this application? And in this paragraph 4 and 5.
Paragraph 4 and
Paragraph 4 and 5. It is not denied that the power conferred upon the High Court under Article 226 and 227 of the Constitution are extraordinary and discretionary powers as distinguished from ordinary statutory powers. No doubt, Article 227 confers a right of superintendence over all courts and tribunals throughout the territories in relation to which it exercises their jurisdiction. But no corresponding right is conferred upon the litigant to invoke the jurisdiction under the said article as a matter of right. In fact, power under this article casts a duty upon the High Court to keep the inferior courts and tribunals within the limits of their authority, and that they do not cross the limits, ensuring the performance of duties by such courts and tribunals in accordance with law, conferring powers within the ambit of the enactments created in such courts and tribunals. Only wrong decisions may not be a ground for the exercise of jurisdictions under this article, unless the wrong is referable to grave jurisdiction of duty and flagrant abuse of the power by the subordinate courts and tribunals resulting in the grave injustice to any party, they will do, Your Lordship. So, in the present case, having a little discretionary power rested upon the trial court to allow amendment applications. Now, we cannot say that it is an abuse of the process of the court, or that it is a dereliction of duty, because certain powers is still there. And therefore, my humble submission is that this amendment application, amendment order, the impugn order may not be interfered with, because and allow the trial to proceed so that there may be no further delay in the proceedings. Oblige, Your Lordship.
Yes, government also. Performa. Any reply?
Yes, Your Honor, my senior will take 2-3 minutes time
Sure.
to reply.
Wait, 1 and 2, general manager and secretary, then we have deputy commissioner. Okay,
Yes.
okay.
Yeah. My learned friend here coming. I don't know whether he has anything to say. Just 2-3 points for clarification, Lordships. My learned friend has tried to show the distinction and difference about the earlier suit and the present suit. Yes, no doubt, it's different, but if
The
Lordship,
plaintiffs are different.
land is different, land is same, and area is same, because it's a big area. Proceedings are also same, all throughout, about the same land. By going through the Plaint, CS2 of 2017, it can be easily ascertained whether the connectivity, whether it is about the same land or different land. So that is very clear, and it not trouble your Lordship on that. But kindly come to page 19. Lordship was making a query about the hearing of the case and all that. So paragraph 9, page 19. Running page 19, paragraph 9. May I just read this paragraph so that it will be clear when it was heard and how, in what manner it was, what judgment was passed. That the matter was heard on 27/4/2021, and order was reserved. On several occasions, matter was fixed for pronouncement of judgment, but judgment was not pronounced until the impugn order was passed on 26/9/2023. The petitioner came to know about the pronouncement of the judgment only in the second week of March 2024, when the counsel for the plaintiff informed that the order was pronounced on 26/9/2023 and amendment was allowed. The said order dated 26/9/2023 was not passed in the open court, and the petitioner has reasonable apprehension that order might have been issued backdated. It is also pertinent herein that to state that as per the cost list dated 26/9/2023, the matter was not listed on 26/9/2023. All along, the petitioner were in the dark about the existence of the impugn order dated 26/9/2023. So that is the date of hearing and in what manner the judgment has been passed. So the abuse of the jurisdiction, if there is any, this honorable court has ample power to supervise such actions. By exercising the supervisory jurisdiction, this honorable court has the power under 227 and 226 to examine this kind of practices. And this kind of practices should be depreciated, Lordship. And secondly, my learned friend has made a submission that they are not praying for occupation and possession. It's not that. I may have overheard because if that is the case, then okay, let that submission be recorded. Other submission was by allowing the amendment petition, the defendants will not be prejudiced. In a smooth, in a humble manner, my learned friend has made that submission. It is as good as just conveying something that by firing the gun, only the person will be died, nothing will happen. By chopping the head also, only the person will die, nothing will happen. Sort like that. But the dispute and the fight in the case is about the title and ownership of the land. And once that is taken away, nothing remains.
No, but what about the submission that they can always file another title suit? But
It
to
is
avoid
open to them.
multiplicity, that also is another ground.
I have no objection in that. But why we are aggrieved, why we are before this honorable court here? Because of allowing the amendment contrary to the provisions of law, it was allowed. That is how we are here. If the plaintiff withdraws the plaint and file a fresh plaint also, that is the prerogative. I have nothing to say on that. And it is always open. That is okay. I have no objection on that. But instead of going to that, what point has been raised in this present proceeding? If it is not proper, this honorable court has to arrive to a finding that yes, what has been done, it is in accordance with law, but what has been done is not in accordance with law. That finding has to arrive by this honorable court so far as this proceeding is concerned. And if it all, they want to withdraw the suit and file a fresh suit also, that is the prerogative. I have nothing to comment on that. And it is always a right for them also. That is how this honorable court has allowed. But they are raising objection that in order to reduce the litigation time, if you are so much concerned for that, in the first place, you could have filed the suit in a proper manner so that more time would have been saved. But since they could not do that, if they want to do it now also, that is okay. But what they are saying now and what they have done do not match. And if you want to withdraw also, it is up to them. But it has to be done in accordance with law. There is a procedure, and the procedure has to be followed. And if it is not followed, then definitely that is questionable. The last submission was on the prayer portion that my learned friend has submitted, that we are not seeking to change the pleadings in the plaint, only the prayer. This is as good as what I have submitted earlier also. Only the prayer. Lordship is well aware. What is the prayer portion? A writ petition, a civil revision petition, a suit, any kind of petition, prayer portion is most vital and important portion, because the entire case will be decided on the basis of the prayer. Now, only by changing the prayer portion, nothing will happen. It is only a prayer portion. The plaint will not be changed. Prayer portion is like the heat in the body of a person. And once the heat is chopped up and another heat is fixed, will it be proper? So by changing, allowing to change the brayer will change the entire thing because any direction given by the court will be based on the brayer. What is your brayer? If I open the case, yes, what is your brayer? What do you want by approaching this honorable court? Ultimately, it will be the brayer portion. If I don't pray, then court will not grant. If I pray, then court will consider on the basis of my prayer. So since they are seeking to change the prayer portion, to change and include the title, we are aggrieved by that, we are prejudiced by that. And the law doesn't permit to do this. So that is my submission, Lordship.
Just one thing, Lordship. Now, my friend says that there is no objection. If I withdraw the petition and file a suit for declaration, then the Supreme Court, it is not my saying, Supreme Court says that yes, for to avoid multiplicity of suits, and by adding the prayer for declaration of title, it does not change the character of the suit. Then how my friend could object to the present application? Then head is not the prayer. Head is the substance of the plaint. Now, on the basis of those facts, you have to come to the prayer. Once to substantiate, to establish a case, your pleading is important. Maybe prayer may be equally important, but the prayer portion is depending on the facts of the case and evidence. The court can grant relief, even if there is no such prayer in the petition.
Today also, I have been while making submission in court number 3, of course, it was through virtual. I have made a submission, one saying that a banana cannot choose to become, a banana cannot decide to become an orange. It remains what it is by nature. And you cannot sit in 2 booths. You can sit only in 1 booth.
Let the court decide which is the hand and which is the body.
The argument that artificial is better than the original is also not valid. Sometimes when we all know that the eggs do not have bones, but if you keep on chewing again and again and again, it appears that there is bones in the eggs. So yes, I also feel that way. That's how many judgments are being derailed by digesting again and again. So we should avoid such practices also. Applies for Lordship's patience hearing.
Council, Senior Counsel for the petitioner, Shri Jamir, assisted by Shri Imran Jamir. Learned Senior Counsel, Mr. Ari Ralu, assisted by Eli Ralu, Mr. K. Angami, Learned Government Advocate for the performer response. Hearing concluded. Action resolved. Processing this also.
Change